Thank you, Chairman, and thank you, Attorney General, for being here. You know, when Uvalde happened nearly 10 months ago in my district, the first elected official to call me was you. And I'll be honest, I didn't have you on my bingo card as being the first call, and I want to thank you for that. And you said something then. You said anything I needed, you would help provide for as we were getting through Uvalde. And you know what? You kept to your word, and I appreciate that. I want to bring something up. I'm very concerned about, and look, I've done my part. I was one of 14 Republicans that helped pass the Safer's Community Act. This is a bill that is going to provide more money in mental health in our nation's history. On this appropriations committee, you know, I helped pass the appropriations to get through some of your funding. Now, one of the concerns I have is with the COPS and the Stop School Violence grants, okay? Some deep concerns with that. And what I've done is a lot of my communities, we're still healing from Uvalde. A lot of my communities are very concerned with their children's safety. Hell, I'm concerned with my children's school safety. And so one of the things that I represent 119 cities and towns in my district. And I've gone to every one of these little towns and I said, you need to put in for COPS grants and Stop School Violence grants. They don't have any grant writers, they don't have any resources, and they've been putting it in. And guess what? They've been denied time and time again. And I'll give you specifics. City of Devine, denied. City of Marfa, denied. Bexar County, denied. Medina County, denied. City of Castroville, denied. El Paso County, denied. These are things that I put letters of support behind, and they've been denied. I had, in Marfa, they have 4 police officers in that town. If the COPS grant, if they would have gotten this COPS grant, they would have gone from 4 to 5 police officers. You know how excited they were? They were going, Tony, we get another police officer, we can do all these different things. They stayed up, I kid you not, they stayed up until 11 o'clock the day before it was due, because I'm pushing them. They submit it and then they get denied. I flagged this for you because in your budget request, you have a reduction, your department has a reduction, a cut in COPS and schools and Stop School Violence grants. It boggles my mind on the discretionary spending for that. It boggles my mind. We just saw what happened in Nashville a couple days ago. Seems like every week there's something that's happening from a school, schools under siege here. I need your help. I'm absolutely doing my part. I need your help. Would love to hear your thoughts on what we can do to get these COPS grants and get these Stop School Violence grants over the finish line.
Okay, so this is you've identified something that I don't know about these specific sheriffs, and I would like my staff to meet with yours to go over these particular grant applications so we can figure out what the problem was there. We've put a lot of money into, and we have it in part of our request now, helping rural sheriffs make the applications, particularly small sheriff's offices, small law enforcement offices, as you've described, sometimes have difficulty. It's not just filling out the paperwork, it's doing the computer work and everything. We've recognized that, and we had a program to make that easier under our OJP grants. Obviously hasn't succeeded here. I do want to say that we are asking, with respect to funding for state and local police, we're asking for more than $4.5 billion this year in both discretionary and 5-year funds. For the COPS hiring program, we're asking for an increase of $2.4 billion this year, not a decrease, an increase, a $213 million increase in the yearly funds and a $2.2 billion in a multi-year funding. The STOPS grants come under the Office of Violence Against Women Act, and they're also increased. It may be that there are 2 parts of these. There's a new gun crime prevention strategic fund, which is an increase of $884 million, or $4.4 billion over 5 years. It will provide some of the funding that used to be in some of the other programs, and that includes hiring, recruitment, retention, training of officers. I think, so we're in no way reducing the amount, we're increasing it. Your offices may still be having the kind of problems that we've discussed, and I'm going to ask my team to talk to yours about it.
I'd appreciate that because this is an important topic that's not going away anytime soon. And what I'm starting to see is people are giving up in the federal government. they're going, why even submit it, Tony? It's a waste of my time. The need is absolutely there, especially in these small communities. We'll work our guts out in our office to help identify these people, vet them to make sure that you're getting good products. I wouldn't put a letter of support behind any of these projects if I didn't do the due diligence on my end, but I need your help. You have a partner up here to get things over the finish line, but I need your help. Thank you, Chairman. I yield back.
Thank the gentleman. Time has expired. That concludes the first round of questions. I believe we probably have a few members who would want to be part of a second round. But so we will do that, but we will take a 5-minute recess.
If I could,
Committee stands in
Mr. Chairman, if I could have an indulgence for just one moment with respect to my answer to Mr. Klein.
Yes.
I've taken a look at that FBI response to subpoena. There actually was a full field investigation. I don't know any of the details about it, but there was. And if you take a look at the letter, I think I said there were none, but it turns out there was one. Thank you.
Committee stands in recess for 5 minutes. Mr. Elsie.
Thank you, Mr. Chairman. Thank you, General. It's good to be here. We've not met before, but as soon as I shook your hand, I understand that you have some pretty thick skin because you get run through the ringer up here, and I appreciate your time and in coming up here. I'll get right to it. Are you familiar with the term, now, Congressman Garcia, Congressman Gonzalez, and I are all in naval aviation in our previous careers. Have you ever heard the terms alligator's closest canoe?
Yeah, I think I've heard it, the nearest bear to the door, but
That's it?
Pretty
All
much
right.
the same, I think.
And have you heard the term stump the chump?
No, afraid of not.
Okay. That means when you ask a question that you're not going to get the right answer on or something like this, it's something to put somebody on the spot. I promise you I'm not going to play that game with you today.
It.
But we are going to talk about the alligator closest canoe. I'm from Texas 6, which is just south of Dallas. I have a 9-county district, which has gotten pretty big, largely rural, not a whole lot of money in the district. And as I look at the budget requests for some of these programs, and I understand you have a very large department. You have a lot of folks working for you, and I know you didn't write this budget request yourself. And then you have to be under the microscope to answer for it. So I'm going to ask you a couple hard questions, namely about the SCAP program, which helps offset the cost of local law enforcement for holding within their jails illegal aliens who are criminals, either have been convicted of a felony or 2 misdemeanors. And previous to that, we had $234 million allocated to that program. And that program's been cut. And I'm curious to know if there's an alligator close to canoe, which is, again, I said I'm not going to play stump the chump. We have a illegal immigration problem. We have a drug problem coming from the border. We have a human trafficking problem coming from the border. I think we can agree with that. So I asked my local sheriffs how much it costs them to hold some of these folks. So I've got 9 counties, but I talked to Sheriff Elmer Tanner of Navarre County, Brad Norman of Ellis County, my home county, Bill Wayburn of Tarrant County. We're still waiting on some of those numbers. There's 254 counties in Texas, and I would argue that Texas is bearing the brunt of what's going on the border. So I heard back from Elmer in Navarre County. He has held 28 of these criminals for a total of 2,067 days. At $69 a day, that's $142,000 cost to Navarre County and the taxpayers of Tarrant County. There's only 52,000 people there. That's real money for counties like mine in my district, like mine. So my question is, if we're going to do away with $234 million program under the justification of more emergent problems like new grant problems like the accelerating justice system reform, which is $300 million discretionary over 10 years, incentivize jurisdictions in undertaking the critical work of addressing the entrenched issues of inequity and disparity, that's not the alligator closest canoe. Who on earth decided to cut that entire program that's going to offset my sheriffs from having to house illegal immigrant criminals for that program? And that's just one of many, but I don't have that much time to go over all of it. So I'd like to see why you can justify cutting that money, justify the request for the other money, and would you be willing to reinstate the SCAP program?
So I think you correctly analyzed my problem here, which is my microscope was not focused on SCAP. And I don't know the answer to your question, but I'd be happy to look at it again, or for myself for the first time, and have our staff talk to yours about the SCAP program and whether there was an alternative source of funding or some other arrangement was made. I just honestly don't know, and my experience before this and other committees is it's best if I say I don't know when I don't know.
Well, that is an acceptable answer. We learned that at the Naval Academy too. That is a perfectly acceptable one. I'd love it for you to look into it because it's important to a district like mine that's not made of money, and we're doing the federal government's job. We do have a problem on the border, and my sheriffs in my district are saying, where's the money coming from? And we just cut all of it. And they were already only getting 31 cents on the dollar to house these illegal immigrant criminals. And that affects my district very, very harshly. So my time's expired. I yield back. Thank you very much for the answer.
The gentleman yields back. The chair is authorized to declare recesses at any time. We welcome everyone to this morning's hearing, and I'll begin by recognizing myself for an opening statement. Mr. Attorney General, we'd like to welcome you to the Commerce, Justice, Science, and Related Agencies Subcommittee today to testify regarding the Department of Justice's fiscal 2024 budget request. Your budget requests a total of roughly $40 billion in discretionary resources for the Department of Justice, an increase of over $2 billion over the fiscal year 2023 enacted level. The department's budget submission outlines positive themes such as upholding the rule of law, keeping our country safe, and administering just courts and correctional systems. However, I'm concerned that these themes simply give lip service to the American people, while the details outlined in your budget fail to adequately address these concerns. The American people continue to be concerned with the skyrocketing opioid epidemic, killing 107,000 Americans last year. Synthetic opioids, such as fentanyl, mainly fentanyl, remain the primary driver of the increase in overdose deaths. A lot of people don't realize that actual deaths from regular opioids is going down, and that the increase in overdose deaths is due solely to fentanyl. In your own budget submission, you note data from the Centers for Disease Control, the National Center for Health Statistics, which indicate an estimated 107,000 Americans needlessly died of drug overdoses during 2021, an increase of nearly 15% from the year before. With that backdrop, we received your budget, which doesn't seem to convey the appropriate sense of urgency. The Drug Enforcement Agency's budget request, for example, requests only 4 additional agents for fiscal year 2024. Additionally, the department's Organized Crime Drug Enforcement Task Force budget, whose mission is to reduce the supply of illegal drugs in the U.S., would actually see a reduction of $25 million and the loss of approximately 70 agents. In spite of the fury of this epidemic that we're in, you're cutting back. Don't understand. We don't have to look far, though, to see where your department's true priorities appear to lie. As the DEA and the Organized Crime Drug Enforcement Task Forces receive little or even less funding, your budget submission requests nearly $45 million across components for zero-emission vehicles to meet President Biden's executive order requiring vehicle fleet electrification. A similar theme can be observed when it comes to your department's efforts to meaningfully combat violent crime across the country. As you note in your budget submission, the United States has experienced a dramatic increase in violent crime incidents, with the number of violent crimes increasing by 29% in 2021. 29% increase in a year. While our federal law enforcement officers have the enormous responsibility of arresting violent criminals, the department also has the responsibility to hold these criminals accountable. Unfortunately, recent actions from the department appear to be sending the wrong message. Our job is to ensure the department's budget is carried out efficiently, effectively, and to the benefit of the American people. I strongly believe that supporting law enforcement and efforts to combat the opioid epidemic should be a top priority for this subcommittee, and it will be. Attorney General Garland, we recognize that you have an incredibly demanding job, and I appreciate you being here today. I hope your testimony will reveal well-reasoned approaches to the many difficult criminal justice issues that affect our local communities. We will endeavor to be respectful of our witnesses' time, and we'll follow up with you should we have any additional questions. So at this time, let me recognize the chair is authorized to declare recesses at any time. We welcome everyone to this morning's hearing, and I'll begin by recognizing myself for an opening statement. Mr. Attorney General, we'd like to welcome you to the Commerce, Justice, Science, and Related Agencies Subcommittee today to testify regarding the Department of Justice's fiscal 2024 budget request. Your budget requests a total of roughly $40 billion in discretionary resources for the Department of Justice, an increase of over $2 billion over the fiscal year 2023 enacted level. The department's budget submission outlines positive themes such as upholding the rule of law, keeping our country safe, and administering just courts and correctional systems. However, I'm concerned that these themes simply give lip service to the American people, while the details outlined in your budget fail to adequately address these concerns. The American people continue to be concerned with the skyrocketing opioid epidemic, killing 107,000 Americans last year. Synthetic opioids, such as fentanyl, mainly fentanyl, remain the primary driver of the increase in overdose deaths. A lot of people don't realize that actual deaths from regular opioids is going down, and that the increase in overdose deaths is due solely to fentanyl. In your own budget submission, you note data from the Centers for Disease Control, the National Center for Health Statistics, which indicate an estimated 107,000 Americans needlessly died of drug overdoses during 2021, an increase of nearly 15% from the year before. With that backdrop, we received your budget, which doesn't seem to convey the appropriate sense of urgency The Drug Enforcement Agency's budget request, for example, requests only 4 additional agents for fiscal year 2024. Additionally, the department's Organized Crime Drug Enforcement Task Force budget, whose mission is to reduce the supply of illegal drugs in the U.S., would actually see a reduction of $25 million and the loss of approximately 70 agents. In spite of the fury of this epidemic that we're in, you're cutting back. Don't understand. We don't have to look far, though, to see where your department's true priorities appear to lie. As the DEA and the Organized Crime Drug Enforcement Task Forces receive little or even less funding, your budget submission requests nearly $45 million across components for zero-emission vehicles to meet President Biden's executive order requiring vehicle fleet electrification. A similar theme can be observed when it comes to your department's efforts to meaningfully combat violent crime across the country. As you note in your budget submission, the United States has experienced a dramatic increase in violent crime incidents, with the number of violent crimes increasing by 29% in 2021. 29% increase in a year. While our federal law enforcement officers have the enormous responsibility of arresting violent criminals, the department also has the responsibility to hold these criminals accountable. Unfortunately, recent actions from the department appear to be sending the wrong message. Our job is to ensure the department's budget is carried out efficiently, effectively, and to the benefit of the American people. I strongly believe that supporting law enforcement and efforts to combat the opioid epidemic should be a top priority for this subcommittee, and it will be. Attorney General Garland, we recognize that you have an incredibly demanding job, and I appreciate you being here today. I hope your testimony will reveal well-reasoned approaches to the many difficult criminal justice issues that affect our local communities. We will endeavor to be respectful of our witnesses' time, and we'll follow up with you should we have any additional questions. So at this time, let me recognize under the 5-minute rule with questions for the witness. I'll begin by recognizing myself. Synthetic opioids, such as fentanyl, remain the primary driver of the increase in overdose deaths. In my home state of Kentucky, for example, more than 2,200 people died from drug overdoses in 2021. Nationwide, more than 107,000 lost their lives, increasing every day and every year. The department's budget submission has listed combating drug trafficking and preventing overdose deaths as a top priority. With that in mind, how can the department claim to be prioritizing the war on drugs when your budget submission for fiscal 24 only requests 4 additional DEA agents? The nation's primary drug-fighting organization, DEA, Drug Enforcement Administration, with thousands of employees, in the face of this overwhelming epidemic that we're up against with fentanyl, a poison, you only ask for 4 additional agents. and a reduction in program funding for the organized crime and drug enforcement task forces. Our cities are afire with violence and illegality, flooded with killer drugs, and you not only don't ask for more help for DEA agents, but you're actually promoting a reduction in funding for the organized crime and drug enforcement task forces. That I can't fathom. If we were to approve your budget submission as is, the organized crime and drug enforcement task forces would lose $25 million in funding and 70 task force agents. And instead, the department would gain nearly $45 million for zero-emission electric vehicles, cars. Does that sound like the budget request for a department that's prioritizing the war on drugs? I don't think so. Today, the DEA has identified Mexican drug cartels as largely responsible for the production of U.S. consumed fentanyl using China-sourced primary precursor chemicals. How is the department addressing and prioritizing the China-Mexico cartel's U.S. drug trafficking pathway, General?
Thank you for the question, Mr. Chairman. I am a former narcotics and violent crime prosecutor. I am very well aware of this problem. The very first thing I did when I came into the Justice Department was to create a violent crime strategy because of the enormous increase we saw in 2020. And therefore, and I have met personally with the families of the victims of the fentanyl crisis. So I'm personally charged with this problem. We are seeking an increase of $342.8 million, a 3.4% increase across Justice Department to counter drug trafficking, a total of $10.4 billion. Now, the budget math and the actual math doesn't always match up. So the actual number of agents that we are requesting are 131, not 4. The reason for the difference in the numbers is that FY23 budget, which only became effective recently, had 127. We're adding an additional 4, and the funding for FY24 will fund the in total number into FY24. In addition, we're seeking 50 diversion investigators and 35 analysts. So the actual total of drug fighting positions we're asking to add to the DEA is 216. OCDF, we're not cutting. We're keeping the same amount in OCDF, $550.5 million. I also want to make clear that with respect to violent crime overall, we are asking for a $1.4 billion increase over last year. This includes increases for the U.S. Attorney's offices, for the DEA, for ATF, FBI, and the Marshal Service, and also particularly important, the way we believe we need to fight both the drug problem and the violent crime problem is in partnership with our state and local partners. So we're asking for a $3.7 billion increase in the grants that we can give for cops hiring, for the Burn JAG, for the new gun crime prevention initiative, so that we can effectively partner in task forces with our state and local partners who are the boots on the ground in the war against both narcotics and violent crime. I want to be clear, this is an extraordinarily high priority for the Justice Department.
What are we doing to intercept or prevent the shipment of the precursor chemicals from China, exclusively from China, through the cartels in Mexico and into the U.S.? What are we doing to curtail the Chinese from forwarding this stuff here?
Mr. Chairman, you put your finger on an enormous problem, which is exactly what you said. Chinese precursor companies are going into Mexico, being made into fentanyl, either powder or pills there. So we're attacking this in several ways. First of all, I've personally gone to Mexico twice to meet with the President of Mexico and with the Attorney General and with the security ministers there. I've met with them all again in the United States several times. trying to press them to cut off these precursors. Together with the Treasury Department, our government has sanctioned some of the precursor companies that we can find in Mexico. We will, as we did with respect to the the Russian oligarchs in Ukraine, we will seize and freeze and forfeit their materials when we find them. So we are doing an enormous amount, I think, to try to cut off this flow, which you are correct in describing as being the ultimate source of our problem.
Mr. Cartwright?
For attending. In your opening statement, you said that you work to uphold civil rights. Is the Sixth Amendment one of those in the Bill of Rights?
The Sixth Amendment is one.
It is, great.
Certainly a civil right.
And you work to uphold civil rights for all Americans, is that correct?
Yes, that's correct.
All right. When the Sixth Amendment of the Constitution says the accused shall enjoy the right to a speedy and public trial by an impartial jury, what kind of a time frame does a speedy trial mean?
Well, there's two different ones. So there's the Speedy Trial Act.
That's correct.
I used to be able to tell you exactly how long it took, but I believe at least the first part I remember is 30 days from the complaint.
That's correct.
I think it's 120 days after that, and then there are exceptions for different motions for speedy trial.
Okay, I believe it says 70 days from the filing of charges of the defendant's appearance
It's been a
before the
long time
judicial
since
officer.
I actually appeared in magistrate's court to make that argument.
Okay, great. I'm glad you are well aware of that. Mark Houck was arrested September 23rd, 2022, and found not guilty on January 30th, 2023. The jury deliberated about an hour. DOJ accused Houck of twice assaulting the volunteer in front of a Planned Parenthood clinic and charged him with 2 counts of violating the FACE Act, freedom of access to clinic entrances. The arrest to the trial took just over 4 months. Would you consider that a speedy trial?
Yes.
All right, so would I. Last week, I visited the D.C. Department of Corrections and met with some of the 20 prisoners who were arrested in connection to the events at the Capitol on January the 6th. According to a Just Security article that came out on March the 20th, 11 of the 20 have not accepted a plea deal, nor have they even been brought to trial. Today is March the 29th, 2023. Attorney General Garland, is it correct that since their arrest, some of these individuals have been waiting approximately 2 years for their trial?
Look, I don't know the specifics of individual cases. The beauty of the Sixth Amendment is that each of those people is entitled to a lawyer, has a lawyer who can make a speedy trial argument in the court. Oftentimes, lawyers ask for more time. Oftentimes, they ask for exceptions for discovery. There was an enormous amount of discovery in those cases, but I don't know anything about particular cases.
Does waiting 2 years for a trial meet the speedy trial clause of the Sixth Amendment?
It can if the exceptions to the Speedy Trial Act are met. Those are the responsibility of the lawyers for those defendants to bring to
Well, I would like you to look into that, because to me, I don't think waiting 2 years for your trial complies with the Sixth Amendment of the Constitution.
This is an argument to be made before the judge. The judge has the authority to dismiss a case for a violation of the Speedy Trial
You're
Act.
absolutely correct. A judge does have that authority. You know, like you said in your opening statement, you work to uphold the civil rights of all Americans. I think in this case, their civil rights are being violated, and I would appreciate you looking into that.
Thank you, Mr. Chairman. I'm listened with interest to the comments of the gentleman from Pennsylvania. I'm glad that he got a response, the minority got a response to their letter. I also sit on judiciary, and my chairman, Mr. Jordan, has asked me to ask you about a letter he sent back in January asking you to appear before his committee. He has not gotten a response to that letter, and so I'd ask you, can I get a commitment from you to respond to him in the immediate future with several dates that would be during which you would be available to appear before the Judiciary Committee?
Of course, I'm going to appear before the House Judiciary Committee. I understand there are discussions about scheduling that have been going on. I don't think there's any problem in that respect.
There's been no response to the letter, so I think there's some question about whether you would be willing to appear. So getting your commitment to appear is helpful, and I thank you for that.
More than willing.
Mr. Chairman, you are talking a lot about the need for more resources to combat increases in illegal gun crimes, correct?
Among many other things, yes.
And let's go down the list. Drug trafficking, you talked about that one.
Yes.
human trafficking, sex trafficking
Yes.
crimes are on the rise. Would you say that those who are prosecuted for those crimes are 100% legal residents of this country?
I'm not in a position to answer that. I'd be surprised if all of them are legal residents, but I don't have statistics on how many are not. But
Would you say that the volume of crossings at our southern border contributes to that rise in crime, just from a sheer numbers perspective?
I don't have the statistics. Obviously, some people who cross the border commit crimes, and some people who, and the vast majority do not.
Right.
Many people in this country commit crimes, and the vast majority do not. I don't have the statistics you're asking for.
But you also would agree that in addition to the migrants who are detained and then released into the country and then commit crimes, increase those numbers of crimes in this country, the number of gotaways who evade apprehension and then commit crimes also increases the number of crimes committed in this country, correct?
I'm stuck in the syllogism here. I think that the answer is the more people who commit crimes, the more crimes we have in the country.
Right. So would you agree then that, and support efforts to try and contain that crossing at our southern border to essentially secure our southern border so that fewer are crossing who are either gotaways or not in this country legally, would help contribute to a decrease in the number of crimes committed?
Yeah, as I was explaining, I think that the Department of Homeland Security, which has the responsibility for the border, obviously, has a notice of proposed rulemaking with respect to funneling all the people to the ports of entry and making the vetting required at those locations or back at an embassy or otherwise, or having to seek asylum first in a country through which they travel, all of which are aimed at the purpose that you're talking about.
Have you taken positions on those proposals to, say, require that you request asylum from the country from which you're coming, in Mexico, if you're coming from a Central American country?
Yeah, so our job, of course, is to look at the legality of the program. The policy is determined by DHS, and we have approved these programs as being legal.
Okay. But you haven't taken any position on efforts to secure the border, which would actually help your department?
We're obviously, let me put it this way, eager to do everything possible to secure the border. I don't think anybody would not feel that way.
All right. I want to go briefly to a conversation we had with IG Horowitz at the most recent open annual worldwide threats hearing in the Senate. FBI Director Wray admitted that the FBI has in the past, according to the Wall Street Journal, bought precise geolocation data before backing away from the practice in the face of thorny legal issues. IG Horowitz last week agreed with my concerns about this disturbing practice. In fact, he said the DOJ, quote, took advantage of legal ambiguities before the Supreme Court's decision in Carpenter v. U.S. And he went on to say that post-Carpenter, of course, that shouldn't have happened. Do you agree with what DOJ Inspector General told the subcommittee last week that government agencies' purchases of information about Americans' location should not have happened after Carpenter?
Yep. So Carpenter occurred during the last administration. My understanding from reading Director Wray's testimony is that, I don't remember what year this occurred in, but that they did take some geolocation data but no longer do so and haven't done so for a couple of years.
Okay, so
I don't know any more than what he testified to.
no parts of DOJ or other agencies are buying similarly sensitive information like about Americans' communications or activity, financial or otherwise?
Well, we've jumped from purchases of aggregate of commercial information.
Well, let's stay there. Are any
those are
parts of
two sep-
DOJ still purchasing
Yeah,
location
so that
information?
question, the department has an investigation going on internally to find out which parts.
But you don't know?
No, because it's ongoing. I don't mean investigation in a pejorative sense, but we're looking into that question. My understanding on geolocation is that we don't purchase that.
Time of the gentleman has expired.
Thank you.
Ms. Ming?
Chair now recognizes himself for an opening statement. The fix is in. Even with the face-saving indictment last week of Hunter Biden, everyone knows the fix is in. 4.5 years. 4.5 years the Department of Justice has been investigating Mr. Biden, an investigation run by David Weiss, an investigation that limited the number of witnesses agents could interview, an investigation that prohibited agents from referring to the president as the, quote, big guy in any of the interviews they did get to do, an investigation that curtailed attempts to interview Mr. Biden by giving the transit team secret a heads up, an investigation that notified Mr. Biden's defense counsel about a pending search warrant, an investigation run by Mr. Weiss, where they told the Congress 3 different stories in 33 days. They told this committee on June 7th, David Weiss said, I have ultimate authority to determine when, where, and whether to bring charges. 23 days later, June 30th, he told this committee, actually, I can only bring charges in my U.S. Attorney's District, the District of Delaware. And then to further confuse matters, on July 10th, he told Senator Graham, I have not sought special counsel status. Rather, I've had discussions with the Department of Justice. An investigation run by Mr. Weiss that negotiated a plea deal that the federal district court declined to accept. A plea deal so ridiculous, the judge asked this question, quote, is there any precedence for agreeing not to prosecute crimes that have nothing to do with the charges being diverted? The response from the DOJ lawyer, I'm not aware of any, Your Honor. A plea deal so ridiculous that the judge also asked, have you ever seen a diversion agreement where the agreement not to prosecute was so broad that it encompasses crimes in a different case? The response from the DOJ lawyer, no, Your Honor, we haven't. An investigation run by Mr. Weiss that not only had a sweetheart deal rejected, but according to the New York Times, there was an even sweeter deal, an earlier deal, a deal in which Mr. Biden would not have to plead guilty to anything. 4.5 years and all that, and now we get a special counsel. Now we get a special counsel, and who does the Attorney General pick? David Weiss, the guy who let all that happen. He could have selected anyone. He could have picked anyone inside government, outside government. He could have picked former attorney generals, former special counsels, but he picks the one guy he knows will protect Joe Biden. He picks David Weiss. And here's what the AG said in his August 11th announcement of David Weiss as the special counsel. Quote, I am confident that Mr. Weiss will carry out his responsibility in an even-handed and urgent manner. Urgent manner, every witness we've talked to, the 2 FBI whistleblowers that came forward, Mr. Shapley, Mr. Ziegler, the 2 FBI agents on the case, Mr. Sobocinski, Ms. Hawley, they've all said this thing was anything but urgent. The FBI said they were frustrated at the pace. Ms. Hawley said she was frustrated at the pace. And of course, the IRS agents, they said the investigation was slow-walked. And even-handed, they limited the number of witnesses that could be interviewed. They tipped off the defense counsel about a subpoena. The judge says the plea deal was a joke. And all that's just half the story. There's one investigation protecting President Biden. There's another one attacking President Trump. Justice Department's got both sides of the equation covered. Look at the classified documents case. Spring and early summer of last year, the Department of Justice asked President Trump to turn over boxes of documents. He does just that. In the process, President Trump finds 38 additional documents. He tells the Department of Justice, the very next day the FBI comes to his home and he turns them over. Then the Department of Justice asked the president to put any boxes he brought from the White House to his home in his storage room and secure it by locking it. He does that as well. Everything they asked him to do, he did. And then what's the Justice Department do? August 8th, last year, they raid President Trump's home. And according to the FBI agent, Stephen D'Antuono, the assistant director in charge of the Washington field office, the search was a complete departure from standard protocol. When we interviewed Mr. D'Antuono, he said, first, the Miami field office didn't do the search. Instead, they sent folks from D.C. He said there was no U.S. attorney assigned to the case. Instead, it was run by D.C., in particular Jay Bratt, who's now on the special counsel team. He said the FBI didn't get President Trump's counsel's approval before they did the search. And then Mr. D'Antuono told us he had recommended that when the FBI got to Mr. Trump's home, President Trump's home, they contact his counsel, wait for him to get there and do the search together. Of course, the DOJ said no. And then who does the Attorney General name as special counsel in that case? Jack Smith, the guy who a few years ago was looking for ways to prosecute Americans, targeted by Lois Lerner and the IRS, looking to prosecute the very victims of the weaponized government, the weaponized IRS. Jack Smith, the guy who prosecuted Governor McDonald, only to have the Supreme Court overturn that prosecution in a unanimous decision. That's the guy that the Attorney General of the United States selects as special counsel. And you wonder why 4 out of 5 Americans believe there are now 2 standards of justice in our great country. Mr. Garland, I anticipate a number of questions on these 2 investigations. Later in the hearing, I expect from Republicans you will also get questions about the many other concerns the American people have with the department. The school board's memorandum, treating Catholics, the memo that said pro-life Catholics are extremists, the Fifth Circuit decision, great decision, on the Department of Justice and other agencies censoring American speech, and of course the FISA law that's up for reauthorization this year, and how that process has been abused and infringed on the rights, the privacy rights of the American people. Americans believe that today in our country, there is unequal application of the law. They believe that because there is. Republicans are committed to making that.
Thank you.
Switching gears, I do want to offer you an opportunity for some rebuttal, because what we've seen from some of my colleagues on the other side of the aisle is their penchant for performance for Twitter and for other news programs. Mr. Attorney General, we've heard a lot of accusations regarding some U.S. attorneys' offices not partnering with Mr. Weiss and hypotheticals about what that means. Can you please explain the difference between partnering with a U.S. attorney's office and acting as a special attorney or special counsel?
I can talk about it, obviously, in the abstract and the theoretical. It's a normal process of the department. If prosecutors from one area of the country and has a case that has significance in another, to speak with the U.S. attorney in the other district, to find out what the policies of the district are, to find out what the practices are, to see how judges in that district react to different kinds of charges. Sometimes decision is made to partner together in those investigations, and sometimes a decision is made for the U.S. attorney from the other district to have his or her own people bring those cases. I have personally been involved in, I think, 3 those cases during the period when I was an assistant U.S. attorney. And over my entire career, I have been given 515 authority twice myself for this purpose. It is not it is just a mechanical question of what courts require in order to make an appearance.
Thank you so much, Mr. Garland. Again, appreciate your public service to the American people. Mr. Chairman, I yield back.
Gentlelady yields back. Does not recognize himself. Quote, Mr. Weiss has full authority to bring cases in other jurisdictions if he feels it's necessary. That was your response, Attorney General, to Senator Grassley's question on March 1st, 2023. You just referenced it when Mr. Bishop was questioning you. Only problem is he'd already been turned down by the U.S. Attorney in the District of Columbia, Mr. Graves. So he didn't have full authority, did he?
I had an extended conversation with Senator Grassley at the time. We briefly touched on the Section 515 question and how that process went. I have never been suggested.
My point's real simple, Mr. Garland. You said he had complete authority, but he'd already been turned down. He wanted to bring an action in the District of Columbia, and the U.S. Attorney there said, no, you can't. And then you go tell the United States Senate under oath that he has complete authority.
I'm going to say again that no one had the authority to turn him down. They could refuse to partner with him. They could not.
You can use whatever language. Refuse to partner is turning down.
Well, it's not the same under a well-known Justice Department practice.
Here's why the statute of limitations question is important, and Mr. Bishop was getting at just a few minutes ago. Here's why it's important. You let the statute of limitations lapse for 2014, 2015. Those were the years with the felony tax charges where Hunter Biden was getting income from Burisma. Here are 4 facts that I think are so important. Hunter Biden was put on the board of Burisma, made a lot of money, got paid a lot of money over those years, a couple $1 million. He wasn't qualified. Fact number 2, he wasn't qualified to be on the board of Burisma. Not my words, his words. He said he got on the board because of his last name. The brand, as Devin Archer said when he was under oath and we deposed him. Fact number 3, Burisma executives told Hunter Biden, we're under pressure, we need help. Fact number 4, Joe Biden goes to Ukraine, leverages our tax money, American people's tax money, to get the prosecutor fired who was applying the pressure. Interestingly enough, that fact is entirely consistent with what the confidential human source told the FBI, and they recorded in the 1023 form, the same form Mr. Wray didn't want to let this committee and the Congress see. That all happened. That all happened. And what I'm wondering is why you guys let the statute of limitations lapse for those tax years that dealt with Burisma income.
There's one more fact that's important, and that is that this investigation was being conducted by Mr. Weiss, an appointee of President Trump. You will, at the appropriate time, have the opportunity to ask Mr. Weiss that question, and he will no doubt address it in the public report that will be transmitted to the Congress. I don't know the answer to those questions.
Did they forget? Did the lawyers just like let it, did they just like, oh, darn, we let it, were they careless?
I expect that won't be what he says, but because I
You
promised...
know that's not the case, because as Mr. Bishop pointed out, they had a tolling agreement. They talked to Hunter Biden's defense counsel and say, let's extend the statute of limitations. And then at some point, they made an intentional decision to say, we're going to let the statute of limitations lapse. And I want to know who decided that and why they did it.
Mr. Weiss was a supervisor of the investigation at that time and at all times. He made the appropriate decisions, and you'll be able to ask him that question, and he will.
You know why they did it? Everyone knows why they did it. May not say it, but everyone knows why they did it. They didn't, those tax years, that dealt with that involved the president. It's one thing to have a gun charge in Delaware. That doesn't involve the president of the United States. But Burisma, oh my, that goes right to the White House. We can't have that. And we can slow walk this thing along. We can even extend the statute of limitations, and then we can intentionally let it lapse. And we know this investigation was slow. Here's what everyone said. Shapley said, DOJ slow walked the investigation. Ziegler, slow walking in the approvals of everything. This happened at the Delaware's attorney's office and DOJ tax level. Mr. Sobocinski, the FBI agent, said, I would have liked to see things move faster. Ms. Hawley said the same. Every witness we've talked to said this thing was slow walked, and we know why. They slow walked it long enough to let the statute of limitations run so they wouldn't have to get into Burisma. Tell me where I'm wrong.
Will the gentleman yield?
No, I'm asking Mr. Garland the
I
question.
think I've tried to make clear that I don't know the specifics of the investigation. Much of what you are describing occurred during the Trump administration, during a Justice Department appointed by President Trump.
No, it didn't. This is 4.5 years, this investigation. We're talking about the last few years. Your statement was just this year, March 1st, to Senator Grassley.
No, I'm sorry. I was trying to respond to your descriptions of what the IRS agents said about certain things.
Statute of limitations is 6 years. That lapsed here in the Biden administration.
On the statute of limitations, we'll say again that the explanation for why the statute of limitation was lapsed, if it was, has to come from Mr. Weiss.
My time is expired. Let me ask one last question real quick here. Who decided that David Weiss would stay on as U.S. attorney?
Look, this had occurred before I came. Mr. Weiss had been kept on. I promised the...
No, I didn't say, you can walk all through that. I said, who decided? The White House decided.
Mr. Weiss...
Right? They serve at the pleasure of the president, right?
Mr. Weiss was...
Joe Biden decided to keep David Weiss as U.S. attorney. You weren't sworn in until March. He was told he was going to stay on in February. Pretty fundamental question. Who decided David Weiss was going to stay as U.S. attorney in Delaware?
Mr. Weiss...
Your time has expired.
Mr. Chairman, your time has expired.
I'm waiting for an answer, and then I'll yield.
Well, you asked the question after your time had expired already. Point of order.
Gentleman can respond, then I'll go to Ms. Jackson-Lee.
Mr. Weiss was the U.S. Attorney from the District of Delaware when I came on. He had been appointed by President Trump. I promised that he would be permitted to stay on for this investigation, and that is what happened.
Gentleman from
Mr. Chairman,
Texas,
Mr. Chairman.
gentleman from New York, Colorado is recognized.
I thank the chairman. Mr. Attorney General, welcome. And my friend and colleague from Colorado outlined your biography, I thought, very well. But he left out 2 points that I'd like to mention. One is, not only did you lead the prosecution of the Oklahoma City bombing case, but in that case, the death penalty was asked for and actually received, and Timothy McVeigh was executed. Not exactly a Democrat priority to seek the death penalty in cases, but you did so because of the rule of law. You did so because the facts and the law demanded that you did so, and you followed the facts and the law in that situation. The other issue I wanted, or example in your bio that I wanted to point out, is my understanding that in your conference room, you have a portrait of Elliot Richardson. And the reason you have a portrait of Elliot Richardson is because he demanded that the Department of Justice stay independent from the Nixon administration. He had the backbone to stand up to the President of the United States and make sure that the Department of Justice would not become the government's lawyer. You put that portrait there soon after you became Attorney General because it was a signal. It was a signal to the world that you wanted to be known in the same way that others that had come before you were known. And frankly, one of the reasons I respect Attorney General Barr so much is because after January 6th, he made the very difficult decision to walk into the president's office and tell the president the election was not stolen. We have looked at this. And for that reason, he resigned before January 20th when power was turned over. But Mr. Attorney General, you're unable to answer some questions here, but I'll answer them for you. Do you know what people would have said if you had asked for U.S. Attorney Weiss's resignation when you became Attorney General? I'm sorry, U.S. Attorney. Yeah, U.S. Attorney Weiss's resignation. They would have said that you were obstructing the Hunter Biden investigation, that you were firing a Republican appointee so that you could appoint a Democrat to slow walk this investigation and lose the leadership of that investigation. If you had made the same decision a year later because you were frustrated that the prosecution wasn't moving fast enough, they would have again said that you were interfering with the prosecution. If you, when U.S. Attorney Weiss asked to become special counsel, if you had made the decision then to appoint someone else to special counsel, people would have criticized you because you would have been taking someone out of the investigation that knew the facts, that could lead the investigation, and put someone in who would have had to come up to speed on the investigation and wouldn't have allowed major decisions to be made until they came up to speed. So in 3 different opportunities where you could have acted, you would have been criticized either way, whether you acted or did not act in that situation. Far from slow walking, really, once the Trump administration decided that that was the person leading the investigation, your hands were tied. You didn't have the opportunity to make a decision on the leadership of that investigation. But speaking of slow walking, I appreciate your reference in your opening remarks, your written opening remarks, to the Department of Justice strongly supports efforts by Congress to promote competition in digital markets by passing legislation to prohibit certain anti-competitive practices by dominant online platforms. You can't say who they are, but I can. Apple, Amazon, Facebook, and Google are monopolies, and they have been harming this country and harming competition in that particular market for years. And Congress for 5 years has been investigating and offering bills on that subject. They spent $250 million, according to reports, in the last Congress to defeat those bills. And now we do nothing in this Congress to try to deal with that very serious issue. In fact, there are efforts, I'm told, over in the Senate, and I use the word effort and Senate very carefully in the same sentence, but there are efforts in the Senate, S 2321, to take $50 million in funding for the Department of Justice Antitrust Division, and it would be an 18% cut, and to move that money to the General Department of Justice Operations Fund to try to further cripple the efforts that are going on in court. The state attorney generals and the Antitrust Division and Federal Trade Commission are doing a great job jointly in trying to combat the scourge of these monopolies. My question to you is, will you make sure that the Antitrust Division is properly funded so it can continue this very serious effort at stopping these monopolies from harming our children, from harming competition, and from further strengthening China's position in this area?
Yes, I absolutely will. And one of the first things I did in the first budget opportunity we had was to ask for more money for the Antitrust Division than had been given in quite a long time, and to ask for the fees that are paid for purposes of merger analysis be given to the Antitrust Division directly rather than to go into a general fund.
Thank you. I yield back.
I would just point out for the record that Attorney General Barr left the Trump administration on December 23rd, 2020, not between January 6th and January 20th, 2021. With that, I recognize the gentlelady.
Mr. Chairman, I'm sorry, since he mentioned monopoly, could I also enter into the record this article about the MasterCard Visa duopoly by Proactive and their target of a bipartisan bill to reform this monopoly? Could I insert that into the record, please?
Yeah, without objection, unanimous consent accepted. Gentleman, floor is recognized, 5 minutes.
I guess I'm just wondering, Mr. Attorney General, has anyone at the department told President Biden to knock it off with Hunter? I mean, you guys are charging Hunter Biden on some crimes, investigating him on others. You've got the president bringing Hunter Biden around to state dinners. Has anyone told him to knock it off?
Our job in the Justice Department is to pursue our cases without reference to what's happening in the outside world.
Just yes or no. Have you done that?
That is what we do.
So it's a no?
No one that I know of has spoken to the White House about the Hunter Biden case.
I'm wondering then,
of course not.
okay, I got it. So Hunter Biden is selling art to pay for his $15,000 a month rent in Malibu. How can you guarantee that the people buying that art aren't doing so to gain favor with the president?
The job of the Justice Department is to investigate criminal allegations. You have
Are
information.
you investigating this? I mean, someone who bought Hunter Biden's art ended up with a prestigious appointment to a federal position. Doesn't it look weird that he's become this immediate success in the art world as his dad is president of the United States? Isn't that odd?
I'm not going to comment about any specific.
Not going to comment, not going to investigate. So
right.
Hunter Biden associate Devin Archer told us that Hunter sold the appearance of access to then Vice President Biden. Are you confident he has stopped doing that?
I'm sorry, I didn't understand the question.
Hunter Biden associate Devin Archer told us that Hunter sold the appearance of access to then Vice President Biden. Are you confident he has stopped?
I'm going to say again that all these matters are within the purview of Mr. Weiss. I have not interfered with them, and I do not.
Yeah, but if you were confident that he had stopped, you could.
And I do not
probably
intend
tell
to
us
interfere with
he
him.
had. So it was a lot of Chinese money that was working its way through these shell companies into the accounts of the Biden family. So the China initiative was set up during the Trump administration at the Department of Justice to go after the malign influence of the Chinese Communist Party. And the Biden Justice Department dissolved the China initiative. So I guess I'm wondering, does the department have any documents that would detail the basis for why you got rid of the China initiative that President Trump had set up?
The Assistant Attorney General for the National Security Division gave a long speech which explained that. He has testified before Congress several times. We'd be happy to provide you with
What's the basis? Just tell us all now. Why was the China initiative dissolved?
What the Assistant Attorney General said was that we face attacks from 4 nation states: North Korea, China, Russia, and Iran, and that we need to focus our attention on the broad range of these attacks. Sometimes we don't know.
Wait a second. Are you saying that North Korea has the same malign influence risk to the United States as the Chinese Communist Party? Are you trying to represent there's some parity there? Because here's what it looks like. It looks like the Chinese gave all this money to the Bidens, and then you guys came in and got rid of the China initiative, and it was successful. Like, I saw one rationale that you guys got rid of the China initiative because it was racial profiling. But one of the people you convicted was a guy named Charles Lieber, who was a Harvard professor taking $50,000 a month to do China's bidding and give him whatever research was being done. Are you aware of the millions of dollars that moved through Rob Walker's shell companies from Chinese Communist Party entities into Biden family bank accounts? Are you aware of that?
There were a lot of questions that you just asked. Let me start with the first one about North Korea. North Korea is a dangerous actor, both kinetically and with respect to cyber.
But not on par with China. I'm on the Armed Services
I'm not in the
Committee, Mr.
business
Attorney
right
General.
now of
It makes you look unserious to suggest
May
that.
I answer your question or not?
Answer the question about whether or not you know about all the millions of dollars that
So
moved
you
through
don't
Rob
want me to
Walker's
answer about North Korea?
I already know the answer, and so does everyone. They're not the same risk as China. So let's get on to serious questions and serious answers. Do you know about the money that moved through Rob Walker's shell companies, yes or no?
As I have said repeatedly, I have left these matters to Mr. Weiss. I've not
Blissfully
intruded.
ignorant.
I've not interfered.
Blissfully
I've
ignorant
not
to these
tried to
things.
find out what
It's
he
like
knows.
you're looking the other way on purpose because everybody knows this stuff's happening. And you know what? People don't pay bribes to not get something in return. Right? The China initiative resulted in the convictions of a Harvard professor, of someone at Monsanto. So we were working against the Chinese. They paid the Bidens, and now you're sitting here telling me that North Korea is the big threat. I got to get to this one thing on January 6th. So did the FBI lose count of the number of paid informants on January 6th?
Let me answer your question about China.
I want you to answer this question. I only get 5 minutes. You've already sort of, I think, screwed the pooch on China. So January 6th, did you lose count of the number of federal assets? Did you lose count and order an audit?
Gentleman's time has expired.
I get an answer to the question of did they lose count?
No, let him answer the question.
The time has expired. The Attorney General can respond.
China is the most aggressive, most dangerous adversary that
Attorney
the
General, I think
United
that-
States faces, and we are doing everything within our power to rebut that, to stop that, to prevent their invasions, both kinetic, and through cyberspace. And we will continue to do
If someone
that.
gave that answer in your courtroom when you were a judge, you would tell them they were being
Mr.
non-responsive
Chairman,
and you would direct them to answer the question.
Point of order, Your Honor.
Time is,
Badgering the witness.
Point of
Time
order,
has
please.
expired.
I got it. I was
You like Your
laughing.
Honor? You want to stick with that?
Yeah, I was getting laughed at to call me Your Honor.
Point of order either way.
Okay, I understand that too.
All right.
But the gentleman asked his question before his time expired. The Attorney General did not respond to the gentleman's question. I was hoping he would respond to the question about the confidential human sources on January 6th. He didn't respond to that. I'm sure we're going to get an answer to that later.
Of course,
Now-
Mr. Chairman.
now
There were
recognize
8
the
questions
gentleman-
before that he was not given a chance to answer.
Understand,
So
but
the witness might have thought.
But the witness doesn't,
This is his
Mr. Chairman,
chance to
point of
answer
order.
the
The witness does not control the time.
hang on, exactly right. Members control the time. If they want to switch their question and focus on one more question that they'd like an answer to, I want to give the witness a chance to respond to that final question that Mr. Gates asked. He didn't respond to it. Someone else is going to ask it, I'm sure. We now recognize the gentleman from Tennessee for 5 minutes.
Thank the chairman and the ranking member for holding this hearing. Thank you, Attorney General, for your testimony, for appearing before us, and for your service to our country. I have great respect for my colleague from Virginia on the other side of the aisle. I'm a bit confused as to why they have zeroed in or focused in on this particular letter in such a myopic way. But your testimony, and I wrote down words here, that the moment he, meaning the Trump-appointed U.S. attorney, Mr. Weiss, asked for the authority, I gave it to him. Seems pretty straightforward. And as you said, the letters that Mr. Weiss has written to this committee are publicly available, and we encourage anybody who's watching these hearings to certainly review those. As you said, clearly they're consistent with each other in terms of reading those letters collectively. I think it's important, Mr. Attorney General, to perhaps talk a bit about your record and your background in light of the various attacks, unfortunately, by my colleagues on the other side of the aisle. My understanding is that you served as a special assistant to the Attorney General of the United States early on in your career. Is that right?
As my first job out of being a law clerk, yes.
Your first job out of law school. You later
Being
were,
out of, after law clerking.
after law clerking, of course. You later were in private practice,
Yes,
and you left private practice to become a line attorney at the Department of Justice,
that's right, to be an assistant U.S. attorney.
an assistant U.S. attorney, a federal prosecutor, taking on organized crime cases, drug trafficking cases, violent crimes.
Yes, I don't know about the organized crime, organized drug trafficking, yes.
Following that service, you served in the Department of Justice as the principal associate
Attorney General.
Attorney General.
Yeah. Deputy Attorney General, yes.
Deputy Attorney General. This is in the mid-90s.
That's right.
And in that capacity, you supervised a range of high-profile cases. Is that right?
Yes, they were high-profile
The
cases.
Unabomber case?
The what?
The Unabomber case.
The Unabomber case, yes.
The Atlanta Olympic bombing.
The Olympic
case.
bombing, yes.
The Oklahoma City bombing case.
Olympic, yes, that's
You
right.
received praise with respect to that latter investigation from the then Republican governor of the state of Oklahoma. Is that right?
Yes, who was a very good partner in the investigation with respect to Oklahoma.
You then were nominated and appointed to the federal bench, the U.S. District Court of Appeals here in Washington, D.C., correct?
For the U.S. Court of Appeals, yes.
Right. You were confirmed by a bipartisan majority. Over 20 Republican senators voted for your confirmation.
I'll take your word for it. I think that's correct.
You served on the bench for a significant period of time, ultimately becoming the chief judge.
Yes, that's right.
You left that position to return to the Department of Justice, where you had started your career.
Yes.
And you were confirmed into this position in which you now hold on a bipartisan basis in the Senate.
Yes.
I think it's unfortunate, Mr. Attorney General, that my colleagues on the other side of the aisle have conflated questions about various cases that the department has brought with impugning your integrity. And I can assure you that the vast majority of the American people don't share their opinion, and that my constituents, the folks back in Colorado, are grateful for your lifetime of service that you have given to this country. And I recognize that this is, I suspect, a frustrating exercise in terms of this particular hearing, because I suspect that you'd like to be talking about the prevalence of fentanyl in our communities and the work that the Department of Justice is doing to interdict it, the gun violence epidemic in our country, and the work that the FBI and other law enforcement agencies are doing to stop it. And my hope is that the next oversight hearing, perhaps those can be the focus, the bulk of the hearing. I'd be remiss if I didn't say one note about a rule that the Department of Justice recently promulgated. As you may recall, in 2021, March of 2021, I sent a letter to the Department of Justice requesting that the Department of Justice issue a rule regulating stabilizing braces. One of these braces was used, as you might recall, at a mass shooting in my community in Boulder, Colorado, where 10 Coloradans tragically lost their lives, including one police officer. And the Department of Justice issued a final rule earlier this year on this precise topic. Unfortunately, my colleagues on the other side of the aisle have made it their mission to overturn this rule. I wonder if you might be able to just elaborate a bit on how the rule was drafted and deliberated within the department.
Yes, well, that horrific event in Boulder was one of several examples of the use of attachment of a semi-automatic pistol to a stabilizing brace intended to permit its firing from the shoulder. That violates the rule, the congressional statute against short-barreled rifles being possessed without registration, anything under 16 inches. The reason for Congress's statute, which I think probably goes back to the Al Capone era, was the power of such a weapon and the ability to aim such a weapon when it's shouldered. All that was done in this rule was to make clear that if you convert a pistol into a rifle designed to be fired from the shoulder, you're subject to the registration requirement.
Thank you, Mr. Attorney General. I yield back.
Attorney Colorado is recognized.
I thank the chairman. Mr. Attorney General, welcome. And my friend and colleague from Colorado outlined your biography, I thought, very well. But he left out 2 points that I'd like to mention. One is, not only did you lead the prosecution of the Oklahoma City bombing case, but in that case, the death penalty was asked for and actually received, and Timothy McVeigh was executed. Not exactly a Democrat priority to seek the death penalty in cases, but you did so because of the rule of law. You did so because the facts and the law demanded that you did so, and you followed the facts and the law in that situation. The other issue I wanted, or example in your bio that I wanted to point out. It's my understanding that in your conference room, you have a portrait of Elliot Richardson. And the reason you have a portrait of Elliot Richardson is because he demanded that the Department of Justice stay independent from the Nixon administration. He had the backbone to stand up to the President of the United States and make sure that the Department of Justice would not become the government's lawyer. You put that portrait there soon after you became Attorney General because it was a signal. It was a signal to the world that you wanted to be known in the same way that others that had come before you were known. And frankly, one of the reasons I respect Attorney General Barr so much is because after January 6th, he made the very difficult decision to walk into the president's office and tell the president the election was not stolen. We have looked at this. And for that reason, he resigned before January 20th when power was turned over. But Mr. Attorney General, you're unable to answer some questions here, but I'll answer them for you. Do you know what people would have said if you had asked for U.S. Attorney Weiss's resignation when you became Attorney General? I'm sorry, U.S. Attorney. Yeah, U.S. Attorney Weiss's resignation. They would have said that you were obstructing the Hunter Biden investigation, that you were firing a Republican appointee so that you could appoint a Democrat to slow walk this investigation and lose the leadership of that investigation. If you had made the same decision a year later because you were frustrated that the prosecution wasn't moving fast enough, they would have again said that you were interfering with the prosecution. If you, when U.S. Attorney Weiss asked to become special counsel, if you had made the decision then to appoint someone else to special counsel, people would have criticized you because you would have been taking someone out of the investigation that knew the facts, that could lead the investigation, and put someone in who would have had to come up to speed on the investigation and wouldn't have allowed major decisions to be made until they came up to speed. So in three different opportunities where you could have acted, you would have been criticized either way, whether you acted or did not act in that situation. Far from slow walking, really, once the Trump administration decided that that was the person leading the investigation, your hands were tied. You didn't have the opportunity to make a decision on the leadership of that investigation. But speaking of slow walking, I appreciate your reference in your opening remarks, your written opening remarks, to the Department of Justice strongly supports efforts by Congress to promote competition in digital markets by passing legislation to prohibit certain anti-competitive practices by dominant online platforms. You can't say who they are, but I can. Apple, Amazon, Facebook, and Google are monopolies, and they have been harming this country and harming competition in that particular market for years. And Congress for 5 years has been investigating and offering bills on that subject. They spent $250 million, according to reports, in the last Congress to defeat those bills. And now we do nothing in this Congress to try to deal with that very serious issue. In fact, there are efforts, I'm told, over in the Senate, and I use the word effort and Senate very carefully in the same sentence, but there are efforts in the Senate, S 2321, to take $50 million in funding for the Department of Justice Antitrust Division, and it would be an 18% cut, and to move that money to the General Department of Justice Operations Fund to try to further cripple the efforts that are going on in court. The state attorney generals and the Antitrust Division and Federal Trade Commission are doing a great job jointly in trying to combat the scourge of these monopolies. My question to you is, will you make sure that the Antitrust Division is properly funded so it can continue this very serious effort at stopping these monopolies from harming our children, from harming competition, and from further strengthening China's position in this area?
Yes, I absolutely will. And one of the first things I did in the first budget opportunity we had was to ask for more money for the Antitrust Division than had been given in quite a long time, and to ask for the fees that are paid for purposes of merger analysis be given to the Antitrust Division directly rather than to go into a general fund.
Thank you. I yield back.
I would just point out for the record that Attorney General Barr left the Trump administration on December 23rd, 2020, not between January 6th and January 20th, 2021. With that, I recognize the gentlelady.
Mr. Chairman, I'm sorry, since he mentioned monopoly, could I also enter into the record this article about the MasterCard Visa duopoly by Proactive and their target of a bipartisan bill to reform this monopoly? Could I insert that into the record, please?
Without objection, unanimous consent accepted. Gentleman from Alabama is recognized.
Thank you, Mr. Garland, for being here today. Every time I'm in my district, constituents are concerned about the weaponization of government, them being selected because they happen to be conservatives. And I think on your watch now, the DOJ actually is a mid-30% approval rating. And, you know, every time the DOJ goes after Trump, he goes up in the polls. I think the American people are starting to wake up to what's going on, and I think it's fairly obvious. And the first question I have is, I understand now that we know that thanks to an FBI whistleblower, that the FBI received information on Americans from Bank of America. Specifically, Bank of America sent the FBI a list of customers who made transactions in the days on and around January 6, 2021. My question for you is, did the Department of Justice acquire any geolocation data from January 1st, 2020 through December 31st, 2021? Yes or no?
I'm sorry, did you say locational data?
Geolocational data.
Geolocational, I believe everything that was done with respect to geolocational data was disclosed in the public filings in the January 6 cases. I don't have that at my fingertips, but this is a matter of public record.
Do you remember any specific analyses that you may have done with that data?
I'm sorry, I can't hear.
Any specific analyses that you may have gotten from that data? Was there anything particular you were looking for, Mr. Attorney General? Like, did they exercise their rights? Did they maybe buy a firearm?
I'm sorry, I don't know anything about the second thing. The purpose, as I understood of the location data, was to determine whether people who claim they weren't inside the Capitol actually were inside the Capitol.
Well, where did the, I guess the question is, to your knowledge, and where the DOJ, geolocation data from external sources, entities, or organizations, to your knowledge, did you receive that from external sources, or are you buying that data?
So I don't know the exact answer in general, but I believe with respect to January 6th, these were the results of subpoena as issued to telephone companies.
So you subpoenaed the telephone companies and then got the data
Well,
from
this requires orders authorized by the court.
Does it concern you that, you know, we talked about Durham's report earlier, that he said that the FBI's activities were somewhat sobering. Does that worry you on your watch that the activities of the FBI have been called sobering now?
I'm sorry, I didn't understand. Who calls it sobering?
John Durham in his report. Did you read his report?
I'm sorry, who?
John Durham.
Durham?
Yes, sir.
I did read the report. All those events had to do with the Crossfire Hurricane investigation. Is that what
That was part of it, yes, sir.
Yes.
Were you concerned when he said it was sobering what the FBI was doing?
I think Mr. Durham, and I just want to make sure everybody understands, Mr. Durham thanked me for not interfering with this investigation. I had promised he would be able to go forward without interference, just as I promised Mr. Weiss. Mr. Durham's, and I did not interfere with his report. His report reported a lack of analytical rigor and a number of other problems with respect to the investigation. I think both the Inspector General made a similar comments, and Director Wray has made the same.
Thank you, Attorney General. I don't have a whole lot of time. I want to yield a little bit to the chairman, but is it a crime in the U.S. to question an election?
I'm sorry.
Is it a crime in the U.S. to question an election? Is that a crime?
I'm sorry. It's my fault. I can't hear. To request a what?
Is it a crime to question an election in the United States of America? It is a crime. Is it a crime for the U.S. citizens to say, we want to ask about this election, we want to question this election, we actually want to look into the election? Is that a crime when citizens just question an election in America now?
Again, I think you're asking not a hypothetical, but something specific about the specific.
I think that's just general. I don't think that's specific. Elections have been questioned for decades past. Is that now a crime in America?
Did you say to ask questions about an election? Is that what you said?
To question an election.
To question.
Just to question
No,
the results.
It's not a crime to question an election.
Because I question the election results in 2020. And there are a lot of people in America that do. And they question the weaponization of government attacking American citizens. And so you, sir, have an issue with trustworthiness of the American people and with Congress at this point. With that, Mr. Chairman, I'm sorry, I'll yield 36 seconds.
No problem. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman, and thank you, Attorney General Garland, for your decades of service to the Department of Justice, to our country, and to our Constitution. It's been truly honorable service, and I think the American public as a whole recognizes that. I was struck by and appreciate your opening statement in which you made crystal clear your fidelity to the U.S. Constitution and the rule of law, and your reaffirmation that the Attorney General is not the President's lawyer. This is a welcome change from the rhetoric and actions of some of your predecessors in the last administration when they appeared before us. As we all should know, the Justice Department works for the American people to prosecute crimes, uphold the rule of law and Americans' individual rights, and keep our country safe. And Congress, of course, has a legitimate duty of oversight. But the blatantly political and misleading rhetoric, which we've been subjected to today, undermines the seriousness of this committee's work and ultimately the legitimacy and core values of our American institutions. It's painfully obvious to anyone who cares about our Constitution that our colleagues have called this hearing not to conduct legitimate oversight, but to once again defend the indefensible actions of the disgraced, twice impeached, and now repeatedly indicted in multiple jurisdictions former president, and to distract from their inability to perform the most basic function of Congress, to fund the federal government. So they're baselessly accusing the U.S. Department of Justice of bias against the former president and his allies. But it's important to note that those who are noisily and shamelessly trying to subvert our justice system are the same ones who seem to have both the most to fear from those ongoing investigations and the most to gain politically and personally from impeding them. As others have noted, these attempts now include trying to defund the Office of Special Counsel, Jack Smith's office, altogether. I, like so many Americans, find this behavior contemptible and far beneath what we should expect from our country's leaders. Mr. Attorney General, why is it so important for both upholding the rule of law and maintaining public trust that our justice system be able to conduct investigations into wrongdoing free from political interference?
The law, the criminal law can impose incredible sanctions on people. It can take away their liberty. That means due process has to be followed during investigations, and that partisan considerations not play a role. That civil liberties and civil rights are protected. And the only way that can happen is if prosecutors are permitted to go about their work without any external impermissible interventions or considerations.
Thank you. I did want to take the opportunity, since this is an oversight hearing, to conduct some actual oversight. And there was an important topic in your testimony, safeguarding the right to vote. During the previous administration, I asked department officials in this committee room what actions they were taking on this critical issue, and they couldn't answer me. So could you describe the efforts that your Department of Justice is taking to protect the right to vote, a fundamental pillar of our democracy?
Yes. The Congress, in the form of the Voting Rights Act and the Civil Rights Act, authorize the department to bring cases and to enforce the Constitution of the United States with respect to the right to vote. As I'm sure you know, in the Shelby County case, the Supreme Court eliminated one of our tools, Section 5 of the Voting Rights Act, but we retained Section 2, which the Supreme Court again endorsed in its last term. So we have brought cases in a number of jurisdictions where we felt that state laws unconstitutionally impinged on the right to vote. We have supported private parties when they've brought those cases, particularly in redistricting cases that violated the anti-dilution requirement of Section 2. We have a task force with respect to threats against election workers, because threatening election workers and stopping them from going about their work is a significant way in which the right to vote can be impinged. That's just a sampling.
And we certainly saw evidence of that in Pennsylvania during the last presidential election. So we really appreciate all those efforts. You know, I find this hearing very disturbing in that we have elected officials misleading the public, attacking the foundations of our democracy, trying to sow distrust on one of the most critical pillars of that democracy, the U.S. Department of Justice. It's unacceptable and it's un-American. Mr. Chair, I seek unanimous consent to enter into the record a fact sheet on the Department of Justice's work under Attorney General Garland's leadership to safeguard Americans' right to vote and protect our election officials and workers.
Without objection.
Thank you. I yield back.
The gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Attorney General, for being here today. I would like to go back briefly to your remarks regarding before the Senate when you were confirmed and your promise regarding Mr. Weiss. Can you explain to us in a little more detail who you promised that you would keep Mr. Weiss on this case? To whom was that promise made?
Yeah, so a number of senators in my meetings with them asked me to make that promise. I think that was discussed in my interchange with a senator from Tennessee, I believe.
And did that promise that you made lead you to believe that even if that Mr. Weiss displayed a level of incompetence, that you would be precluded from asking him to step down or precluded from replacing him?
Look, when someone asks me to make this appointment, they didn't ask me depending upon what the outcome was. Mr. Weiss has made his appointment, decisions, and Mr. Weiss is an experienced federal prosecutor with extensive experience and with sufficient credibility to be appointed by President Trump. I just have no grounds for interfering here.
Right, so you haven't answered the question. The question was really what level of incompetence displayed by a prosecutor under your control would it take for you to make a change? But let's move on. The level of incompetence I'm referring to, I'll just read this to you. This is the same Weiss who headed an investigation that was trashed by whistleblowers who alleged that his investigation had been fixed from the outset. It's the same Weiss who ran an investigation in which agents were allegedly prevented from asking about Joe Biden, obstructed in their efforts to pursue questions, compromised by tip-offs to the Biden team on planned searches. It was the same Weiss who reportedly allowed the statute of limitations to run out on Hunter's major tax offenses, even though he had the option to extend it. It was the same Weiss who did not indict on major tax felonies and cut a plea deal that brushed aside a felony gun charge. It was the same Weiss who inked a widely panned sweetheart deal that caused a federal judge to balk at and trash a sweeping immunity grant, language that even the prosecutor admitted had never been seen in a previous plea deal. So there's a list of what I would suggest under many people's definition would be incompetence. Are you saying that that's inadequate for you to have questioned what he was doing?
I'm saying that all of these are allegations. I don't know what the facts of them are. I have, as I've explained, stayed out of this investigation. I was not present at any of the meetings discussed. Some of the meetings occurred under the previous administration, where Mr. Weiss was assigned to the matter by the previous Justice Department, and I'm not in a position to comment on them.
That's too bad. Is that there's a scope of investigation memo generally issued when we start these things out. Who issued that scope of investigation memo to Mr. Weiss? Was it done back on when he was originally appointed to take on the Biden case? Is that when the memo was telling him what he was supposed to do was issued? Is there a scope of investigation memo is my question.
There's a scope of investigation with respect to special counsel, and that has been publicly transmitted to the chairman of this Judiciary Committee and the Senate Judiciary Committee.
And who wrote it?
Who wrote that scope?
Yeah. Who decided what should be within the scope of that investigation?
I'm sorry?
Who wrote the memo? Who decided what the scope of that?
I decided what should be in the scope. If you'll compare that to the scope of many other special counsels, it basically is modeled on the format that we've used in the past, not only in this administration, but the previous one.
In your remarks delivered on August 11th of this year concerning the appointment of David Weiss as special counsel, you say, upon considering his request, as well as, quote, the extraordinary circumstances relating to this matter, end quote. Can you tell us what those extraordinary circumstances were?
I'm sorry.
Okay, so these are your remarks back on August 11th.
Yes.
And it says, on Tuesday of this week, Mr. Weiss advised me that, I'm just quoting from your memo, this is what
Yes, yes.
In his judgment, his investigation has reached a stage at which he should continue his work as special counsel, and he asked to be so appointed. Upon considering his request, as well as, quote, the extraordinary circumstances related to this matter, end quote, I've concluded it's in the best public interest to appoint him special counsel. What were those extraordinary circumstances you're talking about?
Yeah, look, all of these special counsels, including the appointment by Mr. Barr with respect to Mr. Durham, uses those phrases. The reason it uses those phrases is because that's in the special counsel regulation. I've said as much as I can say with respect to that without discussing matters relating to a pending investigation. I can't discuss matters with respect to a pending investigation for the reasons I've said.
Thank you. Yield back.
Gentleman yields back.
Thank you. Good day, Mr. Attorney General. And this may be the reason that it's good for you to leave the Chief Justice and that group before each of us speak, because you would have already heard all that. I want to thank you personally for your office and your engagement on Camp Lejeune and on obviously a vast amount of litigation. That is one of the many, many jobs that falls at your feet. One of the jobs that falls at our feet here is that we are watchdogs of the executive branch. You have previously said that you are not Congress's attorney, and you've said you're not the president's attorney. And I'm assuming that you're neither our prosecutor nor our defense attorney, and you are neither the president's prosecutor nor defense attorney. And that's why today's investigation really does deal with the fact that if you're not, by definition, the president's prosecutor, but we have an obligation to see whether or not the president or a member of his family or in concert with the president's activities, in fact, need to be overseen, admonished, or even prosecuted. And so I have a couple of questions for you, and one of them is that you have not said this very much today, but you often say, I cannot comment on that because it's an ongoing investigation. And when we ask for information, you very commonly say that it is the policy, not the law, but the policy of the Department of Justice not to provide information related to an ongoing investigation. So far, I'm on track. Is that correct?
I think I've said more than it's just a policy. I think the letters we've sent trace it to the constitutional separation of powers, to Rule 6E of the Federal Rules of Criminal Procedure, et cetera. But in general, I'm in accord with what you're saying.
So one of the challenges we face is that just a matter of weeks ago, a federal judge found the actions of now special prosecutor to be so outside what he could agree to that he pushed back on a plea settlement and nullified it and sent the U.S. attorney going back. In light of that, don't you think it's appropriate for that portion to be considered a pre-ongoing investigation and for Congress to legitimately look at the activities leading up to that failed plea bargain rather than wait until weeks, months, or years from now a case is fully settled?
Yeah. So if you'll give me a chance, first, I don't agree with the characterization of what happened in the plea. The district judge performed her obligations under Rule 11 to determine whether the parties were in agreement as to what each had agreed to and determined that they were not. Plea fell apart, as you know. There's been another prosecution. So that leads to the second thing. We are in, Mr. Weiss is in the midst of an ongoing prosecution on the very matter that you're talking about.
Okay, but Mr. Attorney General, if we believe, and we do, at least on this side of the dais, that a pattern of behavior is occurring relative to the investigation of Hunter Biden, particularly and including, well, he lived in the vice president's home, well, he operated commingled with the vice president, and even today as he travels with the president. So in light of that, can you agree that, in fact, it should be reasonable for us to look at a number of items, including, and one that I want your answer on, and I know we have limited time, Mr. Weiss supposedly had this ability to bring a prosecution anywhere. He now explicitly has that ability. However, Are you concerned, and should we have the right to look into the fact that political appointees in California and in the District of Columbia refused to, in fact, cooperate with him in those investigation that he was charged with doing in Delaware, but which flowed over into their jurisdictions? Isn't that, in fact, an example where those political appointees of the now president, that their decision not to cooperate with him creates at least an appearance of political interference with the investigation of the president's son and possibly activities related to the president?
Look, I'm happy to answer this question in hypothetical, but not in the specifics, because I have stayed out of this matter. In the hypothetical, it is the normal process of the department that if a U.S. attorney in one district wants to bring a case in another, they go to that other district and consult. It's perfectly appropriate. They do that in order to determine what the policies are in that district, what the practices have been in that district, what the judges are like in that district. But a U.S. attorney in another district does not have the authority to deny another U.S. attorney the ability to go forward, and I have assured Mr. Weiss that he would have the authority one way or the other, and I think Mr. Weiss's letters completely reflect that.
Thank you. To be continued.
Time the gentleman has expired. The gentleman from Texas is recognized.
Thank the chairman. Thank the Attorney General for being here before us today. On October 21st, 2021, before this committee, I asked you about Mr. Scott Smith, a father in Loudoun County, Virginia, who was arrested at a school board meeting where he questioned the rape of his daughter in a bathroom in the public school there. You said at the time you were unfamiliar with the case. Are you now, yes or no?
I'm only familiar to the extent I've read about it in the press.
You sent a memo on October 4th, 2021, directing the FBI and U.S. Attorney offices to address, quote, harassment, end quote, of school boards. Yes or no?
I sent a memo to address violence and threats of violence in connection with school personnel.
Directed at school boards.
Not directed at school boards, directed at school personnel, school administrators.
Throughout the country as a priority for the federal government, for the United States Attorney's Office. That followed a letter on September 29th, 2021 from the National School Board Association to President Biden and emails from the National School Board Association Director Chip Slavin to the White House, in which the White House asked for specific threats. And one of the examples was Scott Smith. Subsequent to our hearing 2 years ago, 26 states left the National School Board Association, and Slavin resigned on November 23rd of 2021. Last week, Mr. Smith was pardoned by Governor Youngkin. Do you think the governor was correct, yes or no?
Pardon authority belongs to the governor.
You don't have an opinion on whether the governor was correct?
I don't know the facts of the case, so I'm not in a position to make.
Have you rescinded the memo that you issued in 2021, yes or no?
What we're discussing.
Have you rescinded the memo, yes or no?
What we're discussing here occurred.
Does the memo still exist? Is it still going, yes or no? Has it been rescinded?
The memo was intended to have meetings within 30 days.
Has it been rescinded?
The 30 days have finished. Nothing has happened in more than a year and a half with respect to that
But it
memo.
has not been rescinded, it has not been
nothing
pulled back.
to rescind.
Despite evidence that has come out from the National School Board Association, commissioned report that White House officials discussed this with DOJ more than a week before the letter was sent, the NSBA apologized. Have you apologized, yes or no?
I've testified 7 times since that original memo.
Well, it's the first time you're back here since we talked about it.
I'm sorry?
It's the first time you're back here in front of us. Have you apologized for putting that memo out that implicated Scott Smith as a domestic terrorist, something the governor of Virginia has now pardoned him from all of these accusations?
The memo said nothing about him, nothing about parents being terrorists, nothing about attending school
So
boards.
the answer is it's not been rescinded and you haven't apologized for it.
The answer is that's not
labeling an American citizen a domestic terrorist in a memo and referring to it and a memo that's built on the back of that. But now we had this compliments being driven to the Civil Rights Division. Let's talk about Mark Houck in Pennsylvania, a father who was arrested with heavily armed federal and local law enforcement in front of his wife and children. This after Mark Houck's lawyers had said he would appear voluntarily. Local authorities investigated, found no case. Mark Houck was arrested by the FBI for FACE Act violations. The jury met for an hour. Houck was acquitted. Now, when I was in federal court, I don't remember that being my result very often. In fact, I don't remember happening at all, where we took it to a jury and it was acquitted after an hour. Did you investigate this or question the United States Attorney why they wasted resources for such an obvious result? And can you explain, yes or no, that that was a good use of the Department of Justice's authority?
The Justice Department respects the jury's verdict. The decisions in that case were made by agents and prosecutors on the ground.
Are you concerned that enforcement of the FACE Act has been biased towards pro-lifers over anti-life protesters, 126-4 by our count? And we're asking information to be able to track down the information of such prosecutions, but 126 times against pro-lifers versus 4 times for people who dare to question the issue of life. I'll leave that out there just to say that is the Civil Rights Division at play. Meanwhile, we've got the very liberal progressive groups being targeted as well. Senator Cruz and I sent a letter to you asking for information about how the FBI informant had gone to a liberal group's pro-life meeting, and yet we didn't get any response from you. So I'd ask if you would respond to our letter that we sent back in March asking about FBI infiltrating such a meeting.
I don't know what you're referring to, but I will ask the Office of Legislative Affairs to look into this letter.
Thank you. Finally, our tax cases require approval by Main Justice no matter what district has venue, yes or no? Do tax cases as a general matter require approval by Main Justice no matter what district has venue, yes or no?
It depends on the circumstances. In the example that I know you're referring to.
Generally speaking, yes. Since Main Justice runs tax division, yes or no? Main Justice runs the tax division.
In the Hunter Biden case, I assured Mr. Weiss that
That's not what I'm asking about. I didn't ask it. I haven't mentioned that guy's name. I didn't. I very simply asked a very simple question. Okay. Do tax cases require approval by Main Justice? As a general matter?
Most of the time, but not when the Attorney General has granted authority to a U.S. attorney to do what he thinks is best.
And in a turf battle, if tax division approves changes...
Mr. Chairman, point of order.
I mean, I recall my colleague in Texas having a minute and a half of additional time.
Gentleman's time has expired.
My time, the Chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly, several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached the stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigation.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's 2 brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman.
My time, the Chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly, several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached the stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigation.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's 2 brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentlelady from California.
Thank you, Mr. Chairman, and thank you, Attorney General, for being here with us this morning. You know, as much as we see dirt being thrown in the air, there's a lot of misinformation that I think is intended to confuse people. I would like to ask unanimous consent to put into the record 3 letters from Mr. Weiss that he sent to Congress on June 7th, June 30th, and July 10th.
Without objection.
He said over and over again that he has full authority over this case, including the ability to seek special counsel or special attorney status if needed. Trying to imply otherwise is just simply false. Mr. Weiss was appointed by then President Trump. Your decision was to leave the Trump-appointed attorney completely in charge of this, hands off from you. He makes all the calls without interference from the Attorney General. Is that correct?
That is correct.
And so the idea that you would interfere is completely wrong. And I'd also like to ask, you talked about your independence from the president, but also your independence from the Congress. Have you ever come across historically an instance where the Congress of the United States tried to or successfully interfered with a prosecution initiated by the Department of Justice based on the facts and the law?
I want to be gentle about the word interfere, but it is, just as a historical example, in the case of Iran-Contra, the consequences of actions by the Congress were that the special counsel's investigation of Iran, of Mr. North, were dismissed.
Correct. Before I go into another question I have, I just would like unanimous consent to put into the record the annual statistical transparency report dated April of 2023. It indicates that the deduplicated counting method for FBI queries of U.S. persons under the Section 702 database numbered over 119,000. I would just like to note, and we will work with you, this committee on a bipartisan basis is very concerned about querying of the 702 database for U.S. persons without a warrant. We're not suggesting that the law does not permit that, but we are going to visit this issue because it is my view that querying the 702 database that has been collected without due process, because it relates to foreign individuals, is completely wrong in terms of the privacy rights of Americans. And I'm hoping that we can work successfully with you as we craft requirements for a warrant to do that querying. I'd like to ask, as we know, and has been mentioned by the ranking member, the proposal is basically to defund the police by the Republicans, to defund the FBI. I am concerned that if we defund the police, as the majority has suggested, that really doesn't have an impact on the statute of limitations. So if we were to defund the Department of Justice, defund the FBI and the police, as has been suggested, what would happen with the statute of limitations for cases that you were pursuing if you were not able to actually do that? Would they be suspended anyway, or would the criminals get off scot-free?
Well, I know in my experience as a judge, if I was asked a legal question and I don't know the answer, I would go back to the office and study it, and I'll have to do that in this case. I don't have the answer.
Well, I think I do, because there's nothing in the statute that allows for the statute of limitations to be suspended because the government has been shut down or because the police have been defunded through the budget process. And I just think we ought to take the implications of a shutdown very seriously in terms of allowing criminals to get off. And I see that my time has expired, Mr. Chairman, and I yield back.
It's my time, Mr. Chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly, several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached a stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's two brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman.
My time, the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly, several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached a stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's two brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman. Chair recognizes the gentleman from North Carolina.
Mr. Attorney General, you're the only person who could ensure that Mr. Weiss had all the necessary authority, aren't you?
I'm the only person who can sign an agreement with respect to special counsel. The authority to do Section 515 can be signed by other people in the department.
You're aware, ultimately, though, the authority is yours.
Yes.
You made the point that you don't take orders from the president about such things. You decide, ultimately, what the Justice Department will do.
I announced at the beginning, I promised that he would be able to bring whatever cases he wants, and I have followed through on that promise. I'm permitted to make that kind of promise, and I have made it.
Did you undertake to inform yourself, to interact with him sufficient to ensure that he knew he possessed that authority, or that you would see to it that he had all necessary
I
authority?
don't think there's any doubt that he knew. He has written 3 letters to this committee indicating that he understood he had that authority.
You're also aware, though, aren't you, sir, that a senior IRS investigator, whistleblower, came forward and has testified publicly that Mr. Weiss stated that he did not have such authority. He was not the decider. Are you aware of that?
I'm aware of the testimony. I was not present at any point during that statement. And Mr. Weiss, who was present, has indicated that he had the authority and he knew that he had it.
Subsequent to those developments, though, you decided to make Mr. Weiss special counsel, which you had not done before.
Mr. Weiss made clear he did not ask me to be special counsel until last month, and last month I made him special counsel.
Did you have some lack of information that you should have had that would have caused you to act earlier to make him special counsel?
Mr. Weiss did not ask to be special counsel before.
I understand he didn't ask. You've said that, sir. Did you take the necessary steps to inform yourself what authority he understood he had or what obstacles he was encountering?
Look, Mr. Weiss had, as I said from the beginning, at the very beginning, that he had authority over all matters that pertain to Hunter Biden.
Have you learned that he was in fact deterred by decisions of the United States attorneys in the District of Columbia and the Northern District of California from proceeding as he thought best?
With respect, Congressman, Mr. Weiss has not said that he was deterred. He said that he followed the normal processes of the department, and that he was never denied the ability to bring a case in another jurisdiction.
Well, what changed then, Mr. Attorney General? What made you decide that it was sufficient to leave him in the situation he was until you decided to make him special counsel?
Mr. Weiss asked for that authority, given the extraordinary circumstances of this matter, and given my promise that I would give him any resources he requested, I made him special counsel.
So until that time, was it just a matter of his predilection, or did you undertake to investigate and discern what he was doing with his authority and whether he had faced any obstacles?
I did not endeavor to investigate. because I had promised that I would not interfere with this investigation. The way to not interfere is to not investigate an investigation.
Once he requested to be named special counsel, having not done so over months and months of your tenure, did you ask him what had changed that made him now need to be a special counsel?
Mr. Weiss asked to be made special counsel. I had promised that I would give him all the resources he needed, and I made him special counsel.
When did the Justice Department permit statutes of limitations to expire on some of the prospective charges against Hunter Biden for tax violations?
I don't know anything about the statute of limitations here. The investigation was in the hands of Mr. Weiss to make the determinations that he thought were appropriate.
Are you unaware that statutes of limitations have in fact been allowed to expire after there having been tolling agreements in place?
I'm going to say again, the determination of where to bring cases and which kinds of cases to bring was left to Mr. Weiss.
Yes, sir. I understand that you've said that. That's part of the problem. The question is, are you aware that statutes of limitations have been allowed to expire while the matter was under investigation?
The investigators were fully familiar with all the relevant law.
I'm not asking for the excuses. I'm asking whether you're aware of that fact, sir.
I'm going to say again. I'm going to say again and again if necessary. I did not interfere with, did not investigate, did not
See,
make
those are
determinations.
statements in response to other questions. Everybody in the country now knows who's paying attention to this, that the Justice Department permitted statutes of limitations to expire. Every lawyer who's ever practiced understands the implications of allowing statutes of limitations to expire. Do you not even know as you sit here whether that occurred or not?
Prosecutors make appropriate determinations on their own. In this case, I left it to Mr. Weiss whether to bring charges or not. That would include whether to let statute of limitations expire or not, whether there was sufficient evidence to bring a case that was subject to the statute of limitations or not, whether there were better cases to bring or not.
Time of the gentleman has expired.
My time, the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached a stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's two brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman from North Carolina.
Mr. Attorney General, you're the only person who could ensure that Mr. Weiss had all the necessary authority, aren't you?
I'm the only person who can sign an agreement with respect to special counsel. The authority to do Section 515 can be signed by other people in the department.
You're aware, ultimately, though, the authority is yours.
Yes.
You made the point that you don't take orders from the president about such things. You decide, ultimately, what the Justice Department will do.
I announced at the beginning, I promised that he would be able to bring whatever cases he wants, and I have followed through on that promise. I'm permitted to make that kind of promise, and I have made it.
Did you undertake to inform yourself, to interact with him sufficient to ensure that he knew he possessed that authority, or that you would see to it that he had all necessary
I
authority?
don't think there's any doubt that he knew. He has written 3 letters to this committee indicating that he understood he had that authority.
You're also aware, though, aren't you, sir, that a senior IRS investigator, whistleblower, came forward and has testified publicly that Mr. Weiss stated that he did not have such authority. He was not the decider. Are you aware of that?
I'm aware of the testimony. I was not present at any point during that statement. And Mr. Weiss, who was present, has indicated that he had the authority and he knew that he had it.
Subsequent to those developments, though, you decided to make Mr. Weiss special counsel, which you had not done before.
Mr. Weiss made clear, he did not ask me to be special counsel until last month, and last month I made him special counsel.
Did you have some lack of information that you should have had that would have caused you to act earlier to make him special counsel?
Mr. Weiss did not ask to be special counsel before.
I understand he didn't ask. You've said that, sir. Did you take the necessary steps to inform yourself what authority he understood he had or what obstacles he was encountering?
Look, Mr. Weiss had, as I said from the beginning, at the very beginning, that he had authority over all matters that pertain to Hunter Biden.
Have you learned that he was in fact deterred by decisions of the United States attorneys in the District of Columbia and the Northern District of California from proceeding as he thought best?
With respect, Congressman, Mr. Weiss has not said that he was deterred. He said that he followed the normal processes of the department, and that he was never denied the ability to bring a case in another jurisdiction.
Well, what changed then, Mr. Attorney General? What made you decide that it was sufficient to leave him in the situation he was until you decided to make him special counsel?
Mr. Weiss asked for that authority, given the extraordinary circumstances of this matter, and given my promise that I would give him any resources he requested, I made him special counsel.
So until that time, was it just a matter of his predilection, or did you undertake to investigate and discern what he was doing with his authority and whether he had faced any obstacles?
I did not endeavor to investigate because I had promised that I would not interfere with this investigation. The way to not interfere is to not investigate an investigation.
Once he requested to be named special counsel, having not done so over months and months of your tenure, did you ask him what had changed that made him now need to be a special counsel?
Mr. Weiss asked to be made special counsel. I had promised that I would give him all the resources he needed, and I made him special counsel.
When did the Justice Department permit statutes of limitations to expire on some of the prospective charges against Hunter Biden for tax violations?
I don't know anything about the statute of limitations here. The investigation was in the hands of Mr. Weiss to make the determinations that he thought were appropriate.
Are you unaware that statutes of limitations have in fact been allowed to expire after there having been tolling agreements in place?
I'm going to say again, the determination of where to bring cases and which kinds of cases to bring was left to Mr. Weiss.
Yes, sir. I understand that you've said that. That's part of the problem. The question is, are you aware that statutes of limitations have been allowed to expire while the matter was under investigation?
The investigators were fully familiar with all the relevant law.
I'm not asking for the excuses. I'm asking whether you're aware of that fact, sir.
I'm going to say again. I'm going to say again and again if necessary. I did not interfere with, did not investigate, did not make determinations.
Those are statements in response to other questions. Everybody in the country now knows who's paying attention to this, that the Justice Department permitted statutes of limitations to expire. Every lawyer who's ever practiced understands the implications of allowing statutes of limitations to expire. Do you not even know as you sit here whether that occurred or not?
Prosecutors make appropriate determinations on their own. In this case, I left it to Mr. Weiss whether to bring charges or not. That would include whether to let statute of limitations expire or not, whether there was sufficient evidence to bring a case that was subject to the statute of limitations or not, whether there were better cases to bring or not.
Time of the gentleman has expired.
It's my time, the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached the stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's two brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman.
It's my time, the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached the stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's too brave. Whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman.
My time, the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached the stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's too brave. Whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman from Wisconsin is recognized.
Mr. Attorney General, do you support the consent decree that I believe was put in place in the city of Minneapolis?
I'm sorry, do I support the?
Do you support the consent decree that was put in place with the police department of Minneapolis?
The one was put in place by the federal government,
Yes.
yes. Yes.
Do you support fewer cops on the street?
Do I support?
Fewer cops on the street?
No, I don't support fewer cops on the streets.
That's what's happening as a result of what's
I don't think that's a consequence of the consent decree.
Do you support?
Minneapolis has been losing police officers for many years.
Do you support more crime?
Do I support more crime?
Yeah.
No, I don't.
So there was just a hearing in Minnetonka, Minnesota, a tiny suburb of Minneapolis, just I think this last week, where they're beside themselves with the amount of crime that continues in Minneapolis since the riots of 2020. And I would point out to you that I had an officer in my district. I live right across the border in Wisconsin, or that's where my district begins. A police officer was shot to death as a result of a weak-on-crime prosecutor in St. Paul and Minneapolis, Minnesota. Guy served only 4 years for a violent crime. Do you think that that's a problem?
If an officer is shot to death, that is certainly not an appropriate sentence. That's outrageous. Let me be clear, we are doing everything we can to assist Minneapolis. We have a very aggressive U.S. attorney who's brought a number of RICO and Vicar cases.
Let me continue.
Successful.
I got a real short period of time here.
Sorry.
In regards to disrupting drug networks, why do you think there's so much fentanyl coming into the country?
Because it costs 10 cents to make, and it can be sold for $30.
So Sheriff Mark Daniels from Cochise County, Arizona, sat right where you were at a few months ago, and under oath he said, the reason there is such a drastic increase in fentanyl coming into the country is because on January 20th of 2021, open borders policies were announced by President Biden. Have you expressed concern about those open borders policies that have led to this rapid increase in the amount of fentanyl coming into our country?
I can't associate myself with the conclusion reached by the sheriff, although I can certainly commiserate with the concerns.
So the sheriff is incorrect.
Look, the cartels in Mexico are bringing this, are causing this drug to be transmitted into the United States, and we were doing
Terrific.
everything we can to eliminate that incentive.
Yeah, you're not going to do it doing that. Mr. Chairman, just so we're real clear here, this is the same answer we received from Secretary Mayorkas a couple months ago when he was in denial about a sheriff who lives, one of the most reputable sheriffs you'll find in the United States of America, sitting down there on that southern border. He sees it every day. He saw it working in 2020 because he told me when I was down there. And now he says, it is not working, and it started January 20th of 2021. You can pretend that you're dealing with fentanyl. You're not, because the borders are wide open.
The gentleman from Wisconsin is recognized.
Mr. Attorney General, do you support the consent decree that I believe was put in place in the city of Minneapolis?
I'm sorry, do I support the?
Do you support the consent decree that was put in place with the police department of Minneapolis?
One was put in place by the federal government, yes.
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 Do you support fewer cops on the street?
Do I support?
Fewer cops on the street?
No, I don't support fewer cops on the streets.
That's what's happening as a result of what's
I don't
happening.
think that's a consequence of the consent decree.
Do you support?
Minneapolis has been losing police officers for many years.
Yeah, do you support more crime?
Do I support more crime?
Yeah.
No, I don't.
So there was just a hearing in Minnetonka, Minnesota, a tiny suburb of Minneapolis, just I think this last week, where they're beside themselves with the amount of crime that continues in Minneapolis since the riots of 2020. And I would point out to you that I had an officer in my district. I lived right across the border in Wisconsin, or that's where my district begins. A police officer was shot to death as a result of a weak on crime prosecutor in St. Paul and Minneapolis, Minnesota. Guy served only 4 years for a violent crime. Do you think that that's a problem?
If an officer was shot to death, that is certainly not an appropriate sentence. That's outrageous. Let me be clear, we are doing everything we can to assist Minneapolis. We have a very aggressive U.S. attorney who's brought a number of RICO and Vicar cases.
Let me continue.
Extraordinarily successful.
I got a real short period of time here.
Sorry.
In regards to disrupting drug networks, why do you think there's so much fentanyl coming into the country?
Because it costs 10 cents to make, and it can be sold for $30.
So Sheriff Mark Daniels from Cochise County, Arizona, sat right where you were at a few months ago, and under oath he said, the reason there is such a drastic increase in fentanyl coming into the country is because on January 20th of 2021, open borders policies were announced by President Biden. Have you expressed concern about those open borders policies that have led to this rapid increase in the amount of fentanyl coming into our country?
I can't associate myself with the conclusion reached by the sheriff, although I can certainly commiserate with the concerns.
So the sheriff is incorrect.
Look, the cartels in Mexico are bringing this, are causing this drug to be transmitted into the United States, and we were doing everything we can to eliminate that incentive.
Yeah, you're not going to do it doing that. Mr. Chairman, just so we're real clear here, this is the same answer we received from Secretary Mayorkas a couple months ago when he was in denial about a sheriff who lives, one of the most reputable sheriffs you'll find in the United States of America, sitting down there on that southern border. He sees it every day. He saw it working in 2020 because he told me when I was down there. And now he says, it is not working, and it started January 20th of 2021. You can pretend that you're dealing with fentanyl. You're not, because the borders are wide open. Do you believe, I'm going to shift to combating gun violence. Do you believe that a prohibited person that acquires a gun illegally and disposes it in a dumpster where a criminal or an innocent child could gain access to it should be prosecuted to the full extent of the law?
This is no longer a hypothetical question. You're referring to a specific case which is now in judicial determination before a court of law. It's not appropriate for me to comment on that case.
So for the record, Mr. Chairman, let's understand that the same prosecuting attorney who is now the special counsel gave a sweetheart deal to that person. And yes, you are correct. We're referring to the president's son. He got a sweetheart deal, and the judge was smart enough to smell a rat when she saw it, and she said, you guys go back to the drawing board. That same special counsel is in charge of this investigation. Isn't that correct, Mr. Chairman? Absolutely. I want to close real quickly with this. There was a World Naked Bike Ride in Madison, Wisconsin, just a couple months ago, and I sent you a letter 2 months ago asking if you had a problem with that because it exposed a 10-year-old girl by the race organizer, the bike organizers, to pedaling around Madison, Wisconsin naked. Do you think that's a problem? And why did you not answer our letter from 2 months ago?
I'm sorry, I'll have to ask the Office of Legislative Affairs to get back to you about this.
Does it typically take 2 months to be able to answer questions like this?
It sounds like you're asking about a question about state and local law enforcement. We get hundreds and hundreds and hundreds of letters. I'll ask the Office of Legislative Affairs where that letter is.
State and local law enforcement would not act. We were hoping you would. It's obvious you're not. I yield.
Gentleman yields back. The gentleman.
Do you believe Christopher Wray is a competent director of the FBI?
I think Mr. Wray is a person of the highest integrity, for whom I have great admiration, who has extraordinary experience, both as
Thank
a
you.
career
And so you
prosecutor.
certainly don't think he would knowingly give false testimony to this committee, do you?
I am sure that he would not.
Are you aware that Director Wray a couple months ago in sworn testimony implicated you in a sweeping abuse of power?
I doubt he would characterize whatever he said in that way.
Well, he testified about the school board memo that you issued on October 4th of 2021, in which you mobilized federal law enforcement powers against American parents. Now, of course, you didn't put it quite like that. Instead, you found a pretext, which is stated right here in the first line of the memo. In recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence against school administrators, board members, teachers, and staff. What was your basis for making that claim?
I will say again, as I've testified numerous times in response to exactly the same question, that I saw numerous reports in the press of violence and threats.
You saw reports in the press, and so you decided to instigate a nationwide law enforcement initiative?
If I may be permitted to answer the question.
Please.
Numerous reports in the media of violence and threats of violence against school personnel of all kinds.
Did you consult with the FBI director?
We received a letter from the National Association of School Boards reporting.
Yes, that letter contained anecdotes. It didn't contain data of an increase. Did you, yes or no, consult with the FBI director before issuing the memo?
I don't believe I spoke with the FBI director, no.
Why not? Why wouldn't you consult with the FBI director?
Because the purpose of the memo, as is very clear from the memo, is to ask the FBI to assess the situation, to hold meetings, and to determine whether this was...
Mr. Attorney General, you started with a conclusion that there was an increase in threats. Now, if you had bothered to consult with the FBI director, here's what he would have said. This is from his sworn testimony, that he was not aware of any such evidence. So my question to you, sir, sitting here today, is can you substantiate your claim that there was an increase? Of course, there will always be sporadic criminal activity in all quarters of society, but your claim was there was an increase. Can you substantiate that sitting here today?
I can substantiate that by the reports in the press of violence and threats of violence and by the letters sent by representatives of thousands.
That's a no. You're giving us anecdotes. I'm asking you if you had data. You also said in your memo that you were committed to using the department's authority and resources to discourage these threats, identify them when they occur, and prosecute them when appropriate. Were there any such prosecutions?
The emphasis should be there on when appropriate, and there were no such prosecutions, and that's good news, not bad news.
There were no prosecutions, and in fact, Director Wray said there were no arrests, there were no charges. So you have no data to show us that there was any increase. You didn't even bother to consult with the FBI director, and then there were no resulting prosecutions, even though you said that they were coming. So I have to ask you now, in retrospect, was there a compelling law enforcement justification for the memo?
I think you're mischaracterizing the memo. The purpose of the memo was to hold meetings, to open lines of communication with state.
So is that a no? Yes or no? Was there a compelling law enforcement justification for the memo?
I believe there was a reason to ask for those contacts to be made with state and local law
Well,
enforcement.
the FBI director disagrees with you. When I
Well,
asked
that's
him if
not
there-
what the FBI director said.
Look at it
I'm
right
sorry.
here, Mr. Attorney General. When asked, do you have any reason to dispute the conclusion that there was no nationwide law enforcement justification? He said he didn't.
Either he didn't see the reports or he didn't see the National
This is a
Association of
transcript. I've sent
Schools.
you this transcript, Mr. Attorney General. So my question is this. Will you retract the memo, and by that I mean issue a formal document to the effect that it is no longer operative?
I will not, because there was absolutely nothing wrong with the memo, as I have testified several times already.
Even though
here.
your own FBI director says there was no justification for it, you will not retract it.
The memo is mine. It's my decision whether it's necessary to make assessments like this. And I asked the Bureau to make these assessments, and the other...
Are you familiar with the concept of a chilling effect?
I'm sorry, I didn't...
Are you familiar with the concept of a chilling effect?
I'm very familiar, and that's the very reason...
How would you define a chilling effect
That is-
as it relates to First Amendment
That is the
jurisprudence?
very reason why the second sentence of the memo says
Please
that-
tell me what you consider to be the definition of a chilling effect.
That memo has no chilling effect.
I didn't ask you your opinion on whether the memo has one. I asked you what is a chilling effect.
I'm telling you that the second sentence of that makes clear...
I've read the full memo. I'm asking you, what do you define a chilling effect as?
A chilling effect is when people's exercise of First Amendment rights are chilled by coercive activity by the government, which did not occur here.
So here we're dealing with moms and dads.
Mr. Chairman,
You and I
point
are
of
public
order
officials.
with respect to the time.
Yeah.
Point of order.
The gentleman's time has expired, but it was a pretty darn important question when the Attorney General of the United States can't define what a chilling effect is, so I thought I would let it go a few seconds.
The Attorney General did define what a chilling effect is and said it didn't occur here.
I don't think he defined it, he just dismissed it. The gentleman's time has expired. I thought it was a very important 5 minutes. We now recognize the gentlelady from Florida for 5 minutes.
Good afternoon, Mr. Attorney General. I'd like to return to the earlier discussion about FISA process and the FISC. A number of the members of this committee and of my community are gravely concerned about the well-documented abuses of the FISA process and within the FISC proceedings. In declassified opinions from the FISC in 2018 and 2019, the presiding Judge Boasberg admonished the FBI, stating there still appears to be widespread violations of the querying standard by the FBI, and that there appears to be a fundamental misunderstanding of some FBI personnel about what the standard reasonably likely to return foreign intelligence information means. Mr. Attorney General, what measures has the FBI instituted since that time to ensure that these abuses are stopped?
So we're talking about FBI FISA Section 702?
Yes, sir.
Which is a central part of our ability to find out what foreign nation states, foreign terrorists are trying to do in the United States. I read, when I first came into the Justice Department as Attorney General, I read the opinions you talked about, and they deeply concerned me. And I agreed when I looked into it that there was a misunderstanding by operators as to, and analysts as to what the query standard were. So one of the very first things I did was send a memo to the FBI directing that the way in which the Justice Department, and particularly the FBI, did the querying be examined and that corrections be made. This was an extension of a memorandum that Attorney General Barr had likewise, after he read similar concerns, sent to the FBI at the end of 2020.
And Mr. Attorney General, in addition to other things, the ultimate adjustments included additional attorney oversight, requiring FBI users to affirmatively opt in to search the 702 database, updated guidance and training, and enhanced approval requirements, correct?
Yes, ma'am. All that's true, and the consequence was a 93% drop in the number of U.S. person queries.
Nonetheless, Mr. Attorney General, you would agree, would you not, that there are continued needs to review, analyze, and make additional improvements and safeguards to ensure that we don't continue seeing these abuses?
I do agree.
In fact, in recent weeks, we saw even President Biden's Intelligence Advisory Board make recommendations that we continue to revise 702 oversight and restrictions, including a recommendation to direct the DNI and the Attorney General to research potential technological enhancement to the current oversight framework. Tell me what technology might modernize and improve oversight of the 702 process?
One of the technologies that has already worked very effectively is to change this from an opt-out to an opt-in set of queries. So you have to, first of all, indicate that you are looking at 702 and not just across the board of the FBI holdings. You have to have a drop-down window which explains why you are going to do this. It's easy
Does
for
that
us.
window require the user to input narrative text?
That's right. That's right.
All right. Thank you, Mr. Attorney General. Are there other technology-specific changes that you would recommend?
Well, I'd like to consider that more. There are various kinds of auditing programs using technology. The National Security Division, Justice Department has done some of that. The FBI, actually at the request of Attorney General Barr, began an auditing program like that. FBI Director Wray, who also agrees that these kind of non-compliance shouldn't continue, put that auditing program into effect within the Justice Department.
Thank you, Mr. Attorney General. I yield the balance of my time to the chairman.
General recognizes the gentleman from Wisconsin, Mr. Fitzgerald.
Attorney General, on August 11, 2023, you appointed Mr. David Weiss, U.S. Attorney for the District of Delaware, as special counsel to oversee the investigation of Hunter Biden. I don't think the question has been asked yet. Why did you choose to appoint him as special counsel?
The explanation was given, and and to the extent I can give I'm permitted to give an explanation, is the one I gave and sent to the Congress, which is that Mr. Weiss requested it, that I had promised to give him all the resources that he need, that he had reached the stage of the investigation where he thought it would be appropriate. And under those extraordinary circumstances, I thought the public interest would be served by making him special counsel.
How did Mr. Weiss's name emerge? Who recommended him? How was it brought to you or presented to you that this would be the best person to be the special counsel?
No, I'm not going to get into internal discussions. Mr. Weiss asked that he be appointed as special counsel, and I granted that request and made him special counsel, but I'm not going to get into internal deliberations in the Justice Department.
But I think you said earlier you've had no discussions with the White House and certainly the president in regards to that. Is that accurate?
Of course.
There were no suggestions that came from any other level of government on Mr.
Nothing came from the White House, that's right.
So on August 20th, 2023, the Washington Post article claimed that Mr. Weiss worked with Hunter Biden and Hunter Biden's late brother, Beau Biden. Were you aware that there was a relationship there with the Biden family?
I'm not familiar with this. I don't know when he did what.
They worked together on legal cases in prior years. You were unaware of this?
I'm not familiar with that.
And the article claims it would have been inevitable for Mr. Weiss and the president to cross paths in a state like Delaware. They knew each other. There was a relationship there, but you were unaware of any of this before you appointed him?
I'm unaware of this, but attorneys who are in practice certainly get to know people. So it's very difficult anywhere in the country for attorneys not to get to know attorneys on other sides of matters.
You said previously that Mr. Weiss had the ultimate authority over the investigation of the president's son, including prior to his appointment as special counsel. And you stand by that statement, I'm sure?
I'm sorry, I didn't.
Just that in fact, there was that the ultimate authority was still there with Mr. Weiss to make determinations on that case.
You mean still as special counsel? Yes.
Yes, as special counsel. So the buck stopped there, and that's been determined. According to whistleblower testimony, Mr. Weiss' deputy, AUSA Leslie Wolf, objected to search warrants of President Biden's guest house, denied investigation access to a storage unit containing all the documents from the vacated office of law firm. Is Leslie Wolf still employed by the Department of Justice?
I'm not going to talk about any individuals in the Justice Department. As I said before, singling out individuals has led to serious threats to their safety. I will say that the supervisor of this investigation was Mr. Weiss. He's responsible for all the decisions that were made. Excuse me. Many of the things that you're saying occurred during the previous administration. I apologize.
Okay. Well, there was absolutely a discussion by Leslie Wolf that if they told investigators
or got involved with this, that there would ultimately be issues. You still believe that at this point that the entire investigation has moved in the correct discretion, was handled by the correct discretion of the individuals involved?
Mr. Weiss was a longstanding career prosecutor who was appointed by President Trump. He has an outstanding reputation, and I have confidence that he will proceed as appropriate. And at the end of his investigation, he will submit a public report, just like Mr. Durham, just like Mr. Mueller. He will be available for you to ask him questions about why he did various things that were done.
I yield the balance of my...
The chair now recognizes the gentleman from Texas, Mr. Moran.
Attorney General, you were a line assistant U.S. attorney for years and a federal judge after that. You have significant experience with the processes surrounding criminal investigations. Tell me, what's the normal process for obtaining and executing a search warrant?
You go to a federal judge, you present an affidavit which you believe constitutes probable cause. The federal judge looks at it, makes a determination of whether it does constitute probable cause. He then signs a search warrant, and it's then executed.
And what's the purpose of a search warrant?
The purpose of a search warrant is to find to find evidence of a crime for which there has to be probable cause that it's in that location.
When executing a search warrant on a location that may contain evidence of a crime, what benefits are there for doing so without notifying the putative defendant or the target of the investigation or his attorney ahead of time that execution of the search warrant is forthcoming?
Sometimes you make notifications, sometimes you don't. If you think that the person who has the evidence of a crime is obstructing justice or is going to move the evidence or will secrete it, if you warn them in advance, then you don't give it. If you don't have those concerns, you may give advance notice.
Yeah, so in the instance of not withholding notice, you do so because sometimes they're going to actually move the evidence if you give them a heads up, correct?
It's a general hypothetical matter, yes.
And in most instances, in your experience of decades of law enforcement, have you seen that more times than not, you give a heads up to the defendant, or is it odd to give a heads up to the defendant?
I can't actually make a statistical resolution. I think it's the case that the government tries to use less intrusive methods if they can, and if they can't, use more intrusive and more emergency methods.
I agree with that. But typically, when you're going to execute a search warrant, typically, I think people would understand this from common knowledge, you would not actually give the heads up. Would you agree with that?
I think as a general matter, that's correct.
IRS Supervisory Special Agent Gary Shapley, one of the whistleblowers, testified that AUSA Leslie Wolf told investigators, quote, optics were a driving factor in the decision not to request a search warrant for the guest house at the Biden's Delaware residence where Hunter Biden had stayed for a time. AUSA Wolf further told the investigators that, quote, there was more than enough probable cause for the physical search warrant there, but the question was whether the juice was worth the squeeze. And she further said, quote, a lot of evidence in the investigation would be found in the guest house of former Vice President Biden, but there is no way investigators will get that approved. Now, do you agree with Ms. Wolf that optics of an investigation should be the driving factor in law enforcement decisions when investigating potential crimes?
I have to say again, as I said before, singling out assistant U.S. attorneys is a dangerous matter. The supervisor of that case is Mr. Weiss. He is the one who made decisions in that case. He is the one who can answer questions as to whether those things happened or whether they didn't.
So let's take her out of the equation then. Let's just take the statement generally. Do you believe that optics of an investigation should be a driving factor in law enforcement decisions as to whether or not to execute a search warrant or not?
The Justice Department has standards for its work, and improper considerations are not part of those. The only questions are those driven by the facts and the law.
Mr. Shapley also testified that AUSA Wolf objected to a search warrant IRS investigators requested for a storage unit purportedly containing all of the documents from the vacated office of the law firm owned by Hunter Biden. Investigators scheduled a call with U.S. Attorney Weiss, who agreed that they could search the storage unit if it remained abandoned for 30 days. But immediately after the call, investigators learned that AUSA Wolf had reached out to Hunter Biden's defense counsel to tell them about the storage unit, effectively ruining investigators' chance to access potentially critical evidence. In your experience, As you said earlier, this is not the typical thing that happens, correct?
Look, once again, I don't know anything about these allegations. I don't know whether they are correct or not. These are questions most appropriately put to Mr. Weiss at the appropriate time and to be covered in his report if he thinks that's the appropriate way to resolve.
Can you conceive of a reason why Mr. Weiss or Ms. Wolf would have given a heads up to Hunter Biden's legal team that the search of the storage unit was forthcoming?
I'm not going to get into hypotheticals about this.
For somebody that was involved in the investigation at that point, who was literally delaying obtaining potential evidence in the case, do you think it was appropriate that then she was involved in the negotiation of the IRS deal with Hunter Biden?
I'm not actually following the question. I'm assistant U.S. attorneys who participate in investigation also participate in prosecutions. Is that what you're asking?
Attorney General, I appreciate your time here today, but I'm concerned that these facts are just some examples of what's been going on here where, I apologize, I know my time's out. I yield back. Thank you for your time.
We'll move to 5-minute questions, and we will start with the gentleman from Louisiana, Mr. Johnson.
Thank you. Mr. Weiss, the rule of law does distinguish our country, but you have not upheld that. You have allowed the rule of law to erode, and that's why 65% of the people in this country have no faith in the Department of Justice under your leadership. They don't trust it. They don't trust you. The reason is because they're witnessing every day a politicized Justice Department in a two-tiered system of justice. For example, they see the DOJ, of course, aggressively prosecuting President Biden's chief political rival, Mr. Trump, while at the same time, they see slow walking and special treatment given to the president's son. That's just a fact that everybody can see with their own two eyes. I want to focus on that investigation of the Biden family. We have many important questions for you today about that. Let me just get right to the chase. Has anyone from the White House provided direction at any time to you personally or to any senior officials at the DOJ regarding how the Hunter Biden investigation was to be carried out?
No.
Have you had personal contact with anyone at FBI headquarters about the Hunter Biden investigation?
I don't recollect the answer to that question, but the FBI works for the Justice Department. It's.
I'm sorry. You don't recollect whether you've talked with anybody at FBI headquarters about an investigation of the president's son?
I don't believe that I did. I promised the Senate when I came before it for confirmation that I would leave Mr. Weiss in place and that I would not interfere with his investigation.
Okay,
I have kept that promise.
All right. Have you had personal contact with anybody at the Baltimore field office on the Hunter Biden matter?
No.
On July 10th, 2023, U.S. Attorney David Weiss told Senator Lindsey Graham, quote, I had discussions with departmental officials regarding potential appointment under 28 U.S.C. Section 515, which would have allowed me to file charges in a district outside my own without the partnership of the local U.S. attorney, end quote. With whom did Mr. Weiss have those discussions?
I'm not going to get into the internal deliberations of the department.
But you must, sir. This is important for us. We have oversight responsibility over your department, and we need these answers.
As appropriate, necessary for Mr. Weiss to have conversations with the department. I made clear that if he wanted to bring a case in any jurisdiction, he would be able to do that. The way you do that is to get an order signed by the Attorney General called a 515 order. I promised he would be able to do that, and he in his letters made clear he understood he would be able to do that.
Okay. Can you tell us about any briefings or discussions that you personally have had with Mr. Weiss regarding any and all federal investigations of Hunter Biden?
I'm going to say again, I promised the Senate that I would not interfere with Mr. Weiss.
So you have not, I'm just, under oath today, your testimony is, you have not had any discussions with Mr. Weiss about this matter?
Under oath, my testimony today is that I promised the Senate I would not intrude in his investigation. I do not intend to discuss internal Justice Department deliberations, whether or not I had them.
Oh, okay. So your testimony today is you're not going to tell us whether you've had discussions with Mr. Weiss.
My testimony today is I told the committee that I would not interfere. I made clear that Mr. Weiss would have the authority to bring cases that he thought were appropriate.
Okay.
Mr. Weiss's letter.
Okay, let me stop you. For sake of time, sir, are you aware that FBI officials have come before this committee and they have stated that there was a cumbersome bureaucratic process that Mr. Weiss had to go through to bring charges in another judicial district? You know that?
I'm not aware, but that's not true. There's nothing cumbersome about the process.
So those whistleblowers are lying to us under oath?
those whistleblowers are lying?
I didn't say that. Their description of the process is cumbersome as an opinion. It's not a fact question. All I have to do is sign a
Okay, all
section.
right, let me get to the fact. Mr. Weiss has been the lead prosecutor on the Hunter Biden case since 2018, correct?
I'm sorry?
Mr. Weiss has been the lead prosecutor on the Hunter Biden case since 2018. Now, here's the question.
He's been the lead prosecutor since he was appointed by President Trump.
Okay,
And
why,
assigned-
let me ask you, why has the Justice Department dragged this investigation out for so long? Does it really take years to determine if Hunter Biden lied on a federal form related to purchasing a firearm?
Mr. Weiss was a long-time career prosecutor. President Trump appointed him as the
You're not answering the question. Is that standard procedure? Should it take that long to make such a simple determination?
I'm answering the question. Give me an opportunity to do so.
Okay.
He was charged with that investigation under the previous administration. He's continued. He knows how to conduct investigations, and I have not intruded or attempted to evaluate that because that was the promise I made to the Senate.
The whistleblowers gave us testimony about serious misconduct at the Justice Department in regards to the preferential treatment afforded Hunter Biden. Has your office requested an investigation into that?
There are well-known processes for how whistleblowers make their claims. I am a strong proponent of whistleblowers and a strong defender. We have an Inspector General's office. We have an Office of Professional Responsibility. That is the way in which complaints from whistleblowers should be and are appropriately handled.
I'm out of time. I yield back.
Gentleman yields back. The chair recognizes the gentlelady from Wyoming, Ms. Hageman. We got.
We have been investigating very serious charges made about your department and other elements of the Biden administration, which allege ignoring the law to protect political allies from being held accountable for their wrongdoing. One aspect of this allegation, brought by two very credible whistleblowers from the IRS, demonstrates a strategy of delaying criminal investigation into Hunter Biden and blocking any investigations into the corruption of Joe Biden. The whistleblower testimony notes that U.S. Attorney David Weiss in November 2022 allowed the statute of limitations to expire, even though Hunter Biden's attorney had already agreed to extend the statute on the 2014 and 2015 charges, which charges included an attempt to evade or defeat taxes and the fraud and false statements related to the $1 million that Burisma paid to Hunter Biden while his father was vice president. During a recent transcribed interview with the committee, FBI officials from the Baltimore field office refused to answer questions about the expired 2014 and 2015 tax charges because they were allegedly part of a, quote, ongoing investigation. Are the tax charges related to these years, in fact, part of an ongoing investigation?
Again, I have no familiarity with the details of this particular investigation.
So you don't know one way or the other?
That's right. I left
All
it
right.
up to Mr.
So how are
Weiss.
charges for which the statute of limitations have already expired part of an ongoing investigation?
Again, I don't know anything about this case.
So why would charges that have already expired because of the statute of limitations be part of an ongoing investigation?
To answer in the hypothetical, because I don't know the facts, often charges from previous times are used as part of an ongoing investigation to inform information about intent, about patterns and practices.
For other investigations? So are there other investigations into Hunter Biden where this information may become relevant?
I think it's a matter of public record that there is a tax investigation of Mr. Hunter Biden with respect to other years. I don't
Beyond the
think that's
2014 and 2015?
beyond the ones that are that you were referring to. I think
Okay, Mr. Garland?
Mr. Weiss has already said that during the plea proceeding.
Okay, Mr. Garland, is it standard operating procedure in your Department of Justice for prosecutors to allow the statute of limitations to expire on very serious crimes when the potential defendant has already agreed to an extension?
So there, as I said before, there's no standard operating procedure
Okay.
here. This is
Maybe there should be.
Well,
If this is an oversight hearing, maybe there should be. Maybe you should adopt standard operating procedures to avoid this kind of a circumstance. Would you agree?
No.
Okay.
Because it's left
According
to
to
the
one of the
discretion
IRS,
of
you've answered my question, thank you. According to one of the IRS whistleblowers, quote, the purposeful exclusion of the 2014 and 2015 tax years sanitized the most substantive criminal conduct and concealed material facts, end quote. How can Americans trust an investigation run by a special counsel who, by allowing the statute of limitations to expire, irreversibly, quote, sanitized the most substantive criminal conduct and concealed material facts?
The prosecutor in question is an experienced veteran career prosecutor who was appointed by
And we have no reason to trust him, do we?
by President Trump.
Okay. How much in terms of taxes would Hunter Biden have owed on the $1 million he was paid by Burisma?
Well, as you can imagine, since I don't know anything about the facts of the case, I can't answer
Probably
that
about
question.
$400,000. Isn't that right? I mean, you can do the math. You know the tax code.
I don't know anything about the facts of this case, so I'm not able to do the math to apply it to
And by
facts I
failing to
don't
pay
know.
the taxes on those ill-gotten gains, what would the typical penalty have been, for example, if it was someone who didn't have the last name of Biden or a D behind their name?
I'm sorry. These are all questions you'll have to direct to Mr. Weiss, and that Mr. Weiss will address in his final.
By allowing the statute of limitations to lapse, did Mr. Weiss effectively gift the tax money Hunter Biden owed for the 2014 and 2015 tax years to Mr. Biden?
To say again, the decisions about whether in this area and whether these allegations are correct are ones that Mr. Weiss will be able to answer.
Mr. Garland, one of the things you have done over and repeated over and over and over again is that to point out that Mr. Weiss was appointed as U.S. Attorney by President Trump, as though that somehow inoculates him from criticism by us. Is that really how this game is played? That if someone is appointed by a Republican, then they're supposed to be on the Republican team? Or if they're appointed by a Democrat, they're on the Democrat team? You were appointed by Mr. Biden, weren't you? Are you on the Democrat team?
Let me just be clear. The point of that he was appointed by a Republican counteracts the claim that this was a partisan decision to benefit Democrats.
He remained as a member of the Department of Justice.
Mr. Chairman,
under you.
Mr. Chairman.
Time of the gentlelady has expired. Yields back. The gentleman from New Jersey is recognized for 5 minutes. Joe.
Thank you, Mr. Chairman. Welcome, Attorney General. You know, following your confirmation, Americans were promised they were getting a focused, nonpartisan to lead their federal law enforcement. I had my doubts back then. And the last 2 years have more than confirmed in my mind those fears. Never in my life would I have thought that I would see such a politicized DOJ. Never in my life would I have thought I would see such a Department of Justice that didn't obey their own rules. Never in my life did I think I would see the egregious investigations conducted under your watch, or the blatant disregard of the First Amendment by FBI field officers under your watch. And never in my life did I think I would see our great DOJ turn into a politicized weapon to be wielded by an investigation to attack political rivals. I still hold the thousands of hardworking staff with high regard, but unfortunately there are some within the department, in my mind, who have betrayed their oaths. And for that, you must be held accountable. I hold you accountable for the labeling of parents as domestic terrorists standing up for their proper education of their own children. I hold you accountable for the anti-Catholic memo. Imagine sending agents undercover into Roman Catholic churches because they were supposedly domestic terrorists. And I hold you accountable for unleashing a special counsel with a history of botched investigations on our current president's political rival. The department under your leadership, I am sorry to say, has become an enforcement arm of the Democratic National Committee. If there is a perceived threat to the Democratic Party, this DOJ attacks every single time. But when there are actionable threats against conservatives, this DOJ stays put. Violent protesters outside the Supreme Court justice's home, unpunished. Attacks on pro-life centers, unpunished. The two-tiered system of justice is clear, and it's clear to the American public. And the buck stops with the man in charge. That man is you. The actions of the DOJ are on you. The decline of Americans' trust in our federal law enforcement is on you. The political weaponization of the DOJ is on you. Attorney General, I need a simple yes or no to the following, just yes or no, because we don't have much time. Do you agree that traditional Catholics are violent extremists, yes or no?
Let me answer what you've said in that long list of statements, and
I
I'll be
control
happy to answer all of those.
Attorney
But let me
General, I
just-
control the time. I'm going to ask you to answer the questions I
You
asked.
controlled time by asking me a substantial number of things. And let
I
me
didn't
give-
ask you those things. I
will
made a
answer
statement.
I
Attorney
will-
General, through the chair, I ask you, do you agree that traditional Catholics are violent extremists? Answer
I have
the
no
question.
idea what the traditional means here. The
Catholics,
let me
Catholics
just,
that
can
go
I
to
answer
church.
May I answer your question?
Yes
the
or no?
idea that someone with my family background would discriminate against any religion is so outrageous, so absurd.
Mr. Attorney
It's hard to
General, it
even
was your
answer question.
FBI that did this. It was your FBI that was sending, and we have the memos, we have the emails, we're sending undercover agents into Catholic churches.
Both I and the director
This
of
is
the FBI
the
have said that we
director of
were
the FBI.
appalled. Have said that we were appalled by that memo.
So then you agree that they're
FBI
not extremists?
We were appalled by that memo.
Are they extremists or not, Attorney General?
I think that
Are they extremists or not, Attorney General?
everything in that memo is
Are they
appalling.
extremists or not? I'm asking a simple question. Say no if you think that was wrong.
Catholics are not extremists. No.
Was anyone fired for drafting and circulating the anti-Catholic memo?
You have in front of you the inspection division's investigation.
Just tell me yes or no, please.
I don't know.
We have
the
no
answer.
time.
I don't know the answer to that. There's
Okay.
a
Do you agree that
disciplinary
parents attending
process
school
that the
board
Attorney
meetings should be
General is not
categorized?
permitted
Should
to
parents
intervene
that,
in.
should parents that go to school board meetings and are very vocal about their kids' education, should they be classified as domestic terrorists?
Of course not, and my memo made clear that vigorous objections to policies in schools are protected
So it's no.
by the First Amendment.
The president this week accused you, not the president himself, his staff, and it was in the Wall Street Journal, and it was leaked out, of mismanaging the Hunter Biden probe. Do you agree? Yes or no? It was in the Wall Street
Do I
Journal
agree
article.
with
I'm
the
not
Wall-
saying
I'm
that.
sorry. Do I agree with the Wall Street Journal?
Yes, and that the information they released that said you botched this probe.
Yeah, I think I've dealt with the Hunter Biden investigation in the way I've told this.
Mr. Chairman, I yield my remaining time to you.
I appreciate it. The gentleman yields back. Recognize the gentleman from Kentucky.
Attorney General Garland, Elon Musk was a Democrat who admittedly supported Biden, but then he became a critic of the administration and exposed the censorship regime. Now, per public reports, the DOJ has opened not one but two investigations of Elon Musk. Mark Zuckerberg, on the other hand, spent $400 million in 2020 tilting the elections secretly for Democrats. No investigations whatsoever. To the American public, these look like mafia tactics. You pays your money, we look the other way. You get in our way, we punish you. The American public sees what these tactics are. Now I want to direct your attention to a video here that we're going to play.
Obviously, that's a significant matter. It is an ongoing criminal investigation, and so I'm not going to comment on an ongoing criminal investigation.
Were those pipe bombs operable?
Thank you, Mr. Chairman. Mr. Attorney General, looking again at the appointment of Jack Smith and David Weiss, this double standard of justice couldn't be more glaring. Jack Smith was deeply involved in the IRS scandal that targeted conservative political groups to harass. His malicious prosecution of former Governor McDonnell was unanimously overturned by the U.S. Supreme Court. Chief Justice Roberts rebuked Smith directly for attempting to criminalize political activity. You appointed him to prosecute Joe Biden's chief rival for the presidency. And then we have the appointment of David Weiss. Weiss deliberately allowed the statute of limitations to run out on any charges that could have implicated Joe Biden in influence peddling. He originally offered Hunter Biden a sweetheart deal that was ultimately upended by the court, and he's the one you appointed to pursue the charges that could implicate Joe Biden. That leads me to only two explanations, either corruption or incompetence. So which is it?
Those are the kind of questions that judges would rule out of order.
I'm sure you would. Which is it?
Look, I said before, and I will say again, Mr. Weiss was the Republican-appointed United States Attorney appointed by President Trump.
Do you at least do you at least see the obvious double standard applied in these two appointments?
Mr. Weiss was a Republican appointee. Mr. Smith is not registered to either party. His entire career was as a career prosecutor.
I'm not asking what their party registrations are. I'm asking about their records and how those records would commend them to the appointments that you made. This is a question of judgment, and it's a question of motive. What was motivating you to do this?
Mr. Smith had a nationwide reputation for integrity and for appropriate prosecution. His work can be measured by what he actually has filed. Everyone in the country can see the indictments.
How can you
that he
say
has
that after he was so heavily implicated in the IRS scandal or the rebuke that the Supreme Court gave and many other examples? But let me go on. We've had two IRS whistleblowers inform Congress of attempts by senior Justice Department officials to obstruct a criminal investigation into millions of dollars of ill-gotten and undeclared income to Hunter Biden. They noted several deviations by department officials from normal process that provided preferential treatment, in this case to Hunter Biden, a direct quote, including allowing the statute of limitations to lapse, requesting IRS and FBI management level investigative communications, prohibiting investigators from referring to the big guy or dad in witness interviews, excluding the investigative team from meetings with defense counsel, and notifying defense counsel of pending search warrants. The U.S. Attorney's Office even tipped off the Bidens of an impending search of a storage unit where their records were being kept. Now that sounds an awful lot like obstruction of justice to me. Was that coming from you or from somebody else?
I'm sorry, I don't was that coming from you? I don't understand the question.
All of the actions that your employees took to obstruct the investigation of Hunter Biden and the earnings that he made and the taxes he failed to declare, their source, and ultimately who they were paid to.
I'm going to say again with respect to the Hunter Biden investigation that it has been and still is in the hands of Mr. Weiss, an appointee of President Trump. I don't know about all of these allegations. Some of them appear to have been from the period when the Attorney General appointed by President Trump was still the Attorney General.
Do these charges trouble you at all?
Mr. Weiss will have an opportunity to explain the decisions.
Well, you're the guy in charge. Does this trouble you?
I have intentionally not involved myself in the facts of the case, not because I'm trying to get out of responsibility, but because I'm trying to pursue my responsibility.
Your FBI director testified before this committee of an uptick in, quote, known or suspected terrorists coming across the southern border. And he told us that the southern border represents a massive security threat. Those were his words, a massive security threat. Do you agree?
I am perfectly happy to align myself with the director of the FBI.
Well, why is it then that we, senior administration, rescind the Trump-era orders that had secured that border? We've seen an exponential increase in suspected terrorists.
Time of the gentleman has expired. The witness can respond if he chooses.
This is the answer to this question about immigration law is an extremely long answer. I would defer to the Department of Homeland Security, which is responsible for the physical security and about first contact at the border.
Well, we've tried to get answers from him, and he doesn't give them to us, so we're hoping you would. I understand, Mr. Attorney General, you've requested a short break, so we'll take a short break and resume in 5 minutes.
Okay, sorry.